Eight, please. But I beg to mention item number 39, my lord. The consent of other side. I appear on behalf of the respondent, my lord. There's a leave petition. File our objection. I'm seeking 3 weeks time, my lord. My client is.
39.
Yes, yes.
What is this?
But this is a leave application against appeal, my lord.
Prayer of Mr. Dubey, learned counsel for the respondent and with the consent of the petitioner side, release the matter. Be known.
Deeply obliged.
May I please, Your Lordship? I beg to mention item number 35, Lordship. Agent for the day, Lordship, is we are looking for some documents, Lordship. And it is longly listed as bail hearing, Lordship. It should come up as motion, Lordship.
35.
35,
Is
Lordship.
the matter in the motion column
Vacation, Lordship.
after vacation? Yes.
Obliged.
Please, Lordship. Lordship, in regard to item number 46, an adjournment slip was submitted yesterday. The conducting counsel, Mr. C. N. Saiwala, is unable to be present over today. And even the petitioner's counsel is traveling from Delhi. So he couldn't be present over today. I'm seeking a date on either 4th or 5th or 6th of August. 46, right? Obliged, Lordship.
May it please, Your Lordship. Lordship, I beg to mention item number 53, my lord. Supplementary is. Pass over for the day, my lord.
Go for the day.
May it please, Your Lordship, I beg to mention item number 43, Lordship. Kindly adjourn the matter today and fix it after vacation, Lordship.
Not received.
CD received.
Criminal petition.
Yes. After vacation was. Can back.
Yes, so bless, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 9, Lordship. Lordship, actually, in the instant case, Lordship has already gone through the case study and granted bail to 2 of the co-accused. And today my matter is fixed in the motion. And upon inquiry before the concerned police station, they informed that the case study is there in the court premises itself. So my humble prayer is if the learned PP madam could produce the case study on going through her office, Lordship.
Fine. Okay, we'll take it up a little later then. Find a case diary.
Tomorrow, Lordship.
Who is the
If it
last
is
day?
available, Lordship.
Lordship,
If we can, let us take it today itself. What is it? You can find it. Send a message to someone in your office. Look at the diary.
Source it has been filed.
Yes. What is the offense?
My lord, the offense is, my lord, under section, my lord, 64, 69 and 82 BNS, my lord. So he is behind the bar, my lord, since last 35 days, my lord. Team guard has already been recovered, my lord, and that she is with her parents, my lord. In fact, my lord, there was, my lord, some relation with the victim and the petitioner, and that, my lord, the victim were in fact voluntarily went to the house of the accused petitioner, and that he was handed over to the parents by the family members of the present petitioner. Your Lordship will find at the FIR is number 11.
Rapist, Your Lordship.
That she was coming back from her college, and she was taken from, allegedly she was taken from her way. She made no hue and crime law. That would sufficiently indicate that if actually she was taken, then it was with her consent, my lord. And that, my lord, FIR was
the TCR then.
FIR was lost after 20 days, my lord.
TCR.
My lord.
CD, please hear it, CD.
I have a date, my lord. Published, my lord.
Lordship, item number 3 is concerned, the CD was called for today, Lordship.
If CDs are not available here, Lordship.
My grievance before your Lordship, that I was sent to the custody after 24 hours in violation of fundamental right, and same is also I am relying in the Lordship judgment in Sumanuddin case, Lordship. Where that's it. If Lordship, item 3, Lordship,
In the case study, Lordship, as on today, 35 days behind the murder.
Lordship, page
And the
25.
murder for the 35 days last. The case study, Lordship.
Page 25, Lordship, for one moment, Lordship, item number 3, Lordship.
Reason we call for the case diary is because without it, we cannot decide
Lordship,
whether
yes,
your
I
perception
understand,
is
but
correct.
But they have not produced, just I am for my satisfaction, Lordship. That this is Lordship seizure list, Annexure 5. Here, Lordship, date and time of seizure is shown as 21st of May 26 at 3:30 p.m. Now, Lordship,
Where, page?
Lordship, 21st of May to
Page.
page 25, Lordship. I was apprehended in 11 a.m. on that day, and seizure was made page 25, Annexure 5, Lordship. Date and time, Lordship. Lordship got it. 21st May 2026 at 3:30 p.m. Even prior to that, Lordship, I was with the police. Police apprehended me at 11:30 p.m. a.m. Lordship. And Lordship, page now, Lordship would bear with me, Lordship, Annexure 2, page 15 for my forwarding report, Lordship. The 11th page, Lordship would kindly see at page 16, at the bottom, Lordship. That production before this court at 4 p.m. on 22/5/2026.
Page?
Page 16, Lordship. Start from page 15. That next down, left top below the production before this court at 4 p.m. on next day. And listen,
Where is it?
Lordship, in page 16 in the bottom, Lordship, by handwritten, Lordship. Production before this court at 4 p.m. Lordship got it. On 22/5/26, next day.
What is the
And next, Lordship, arrest.
place of arrest?
Lordship, place of arrest at current Sunari Loss PS, Lordship. Next page, Lordship, arrest memo, page 17.
Place of arrest, the address of the place, where is it?
Sunari PS. Next page, Lordship. Arrest memo. Date
But
and-
he came with the articles to Sonari PS.
No, Lordship, yes.
Huh?
Lordship, I have been apprehended at Karantinali at
That
Hibohava.
is what I am asking.
Yes,
You
I
keep
have-
repeating Sonari PS, Sonari
Yes.
PS.
I have been brought to Sunari PS, Lordship.
Say that.
Lordship, kindly find date and time of arrest at arrest memo, page 17. 22nd May at 11 a.m. There is a difference. Next page, Lordship, Annexure 4, 48 notice, Lordship. CL number 8, Lordship, date and time of arrest. 22nd May at 3:30 p.m. In arrest memo and notice under section 48, different time. The FIR lordship page 13, it will reveal that they have intercepted me at 11 AM.
That is why we need the CD.
Yes, lordship.
But they have,
Yes, and anyway, your difference is half an hour only. Whatever travel time.
no, lordship, I was apprehended at 11:30 AM, lordship.
No, according to you, it is 3:30 PM.
No,
You are
3:30
showing the seizure list.
Lordship, 3:30, the seizure was made from me.
Yes, then
After-
you are not arrested at 3:30.
No,
You were arrested at 11.
11. I was.
11:30 on the same day you were produced at 4.
No, no.
So you have
on the
no
next
case.
day.
What? You say but 22nd.
Oh, yes, but I was apprehended on 21st.
No, what is that 11 time? Where is that?
11 time, lordship, page.
Page 17, date and time of arrest 22nd May 11 AM.
It was shown, lordship.
What shown? You are saying you are relying on this.
No, I am showing,
But
relying it
in
the
this
arrest memo
statement,
found
lordship.
to impress upon this court.
Go back, prepare and come. Don't make useless submissions here.
I could not make you understand, but my case is that, lordship, I was arrested on 21st.
You have no case. You are arrested at, even going by the seizure list, it's 3:30. You were produced at 4 before the magistrate. Half an hour difference, that is with travel time. And if you insist it is only at 11:30, that is on the same day, on 22nd.
No, lordship, 11, they have shown.
Where is the time 11:30 at
Page
on the
30.
previous day?
Page 13.
Where is that?
Page 13, lordship, FIR.
Where is that?
Page 113.
Yes, information was received at 11:30. Where does it show that at the Naka point he was apprehended at 11:30?
Yes, lordship.
He received the information at 11:30 in the police station and arrested him at 11:30.
No, lordship.
Then?
I was I was apprehended at the Naka point, lordship.
Yes, at what time? Show from the FIR. Wasting our time unnecessarily. Yes, she did not receive. List again on to answer.
Item number 2 also arising out of this case.
Lordship, item 3, lordship, I may be allowed to withdraw, lordship. I'll try.
Yes, we know.
Obliged, sir.
So lordship may fix it after vacation, man. TT9.
Which?
Item 2.
Item 2, man. Oblige, your lordship.
May I please, your lordship. This is regular bail application, lordship, and in this case, lordship, the out of same providing same FIR, lordship. The court is already grant bail, lordship, and I am providing this order, lordship, and based on the affidavit shown by the informant, lordship.
But were co-accused, granted bail.
Yes, lordship, I am
Where
providing.
is the order?
And the informant and the petitioner is the same sibling, lordship. Younger petitioner is the elder brother, and the informant is the younger brother, lordship. They have already amicably settled, and then lordship, the petitioner having no any involvement at all.
One is Baharul, one is Hasina.
Lordship, Hasina is my daughter, Lordship, and Baharul is my son-in-law. The informant is my
Same party.
Lordship. Same affair, Lordship. Hasina is the PA, Lordship. And petitioner is a government employee, Lordship, and he is a
Here in our case, informant is Syed Ali Bhuyan.
Syed Ali.
own brother, Lordship, younger brother.
Who is the petitioner today?
Lordship at the Soleiman Ali Bhuyan,
Suleiman.
Lordship.
How let you pass the same order? Order.
Deeply obliged, Lordship. Deeply obliged.
The matter is fixed on 2107, Lordship.
Which one? No, I think it is disposed of.
Disposed of. Earlier one is not disposed of, right?
Huh?
Interim, Lordship.
Interim.
Yes, 21/7.
Lordship, we have already received the case file. Here.
In this case, you say CD is take up together on that day.
Lordship. So CDB sent back, Lordship?
All right, CD is sent.
Obliged, Lordship. Deeply obliged.
Here petitioner is in custody for 63 days. FIR, your lordship will find page 8. Here one person lodged an FIR alleging that from his dhaba, some commercial cylinder, 2 commercial cylinder, 2 domestic cylinder and 1 TV, along with lordship cash amount of 4,400 were stolen by some unknown person. And in connection with that, one inquiry was conducted by the police lordship. Page 9, your lordship will find that inquiry report, which clearly says that one Vicky and one Ridip Das, they stolen those articles from that dhaba. And present petitioner is the lordship receiver of those one of the TV lordship. That your lordship will find middle person of page 9. Shahjahan Ali, son of so presently residing at Dharapur, who received the stolen TV and later handed it to Gopal Setri. So this is my involvement, lordship. And my case is that, lordship, I have purchased it, lordship, for 2,000 and subsequently that Gopal Setri offered me some money and accordingly I sold him for rupees 3,500, lordship. That is my involvement, lordship. And already 63 days in custody, lordship. He was not involved in that theft, lordship. A bona fide purchaser of 1 TV, lordship. That is it.
Charge sheeted.
No, not charge sheeted, lordship.
Then
That
63 days.
One of the section is habitual offender, that is against the prime accused who have stolen that article, lordship. In the forwarding report, it is mentioned that they are habitual offender. That your lordship will find in the forwarding report page 19, lordship.
What is the punishment?
Regarding lordship, that habitual offender more than 10 years. So therefore, it is case of 90 days. Then that allegation is against
Which
Vicky Das
section?
and Ridip Das.
Which section?
317 subsection 4, lordship.
ENS.
Lordship.
DNS খন কোন? এইকেইখন একখন ৰেডি কৰি থৈ নিদিয়া কিয়?
So 10 years.
Yes, what was it?
317 subsection 4, it is for up to 10 years, Lord. So it will say imprisonment extendable up to 10 years. Imprisonment for life or imprisonment for 10 years, section 317, subsection 4.
Lordship,
But minimum punishment is not 10 years.
Minimum is not 10 years.
Then will it be 90 days or 60 days as per Rakesh Pal?
Lordship.
60 days, Lordship.
Huh?
minimum.
60 days.
As of now, Lordship, charge sheet.
Minimum has to be 10 years for the period to be, statutory period to be 90 days. I think that is settled in Rakesh Pal's case.
Lordship, his other associates are also engaged in multiple cases, NDPS cases.
No, but he is 63 days.
Yes.
Don't state it, default bail or otherwise.
Take instruction whether.
After some time, Lordship may take up the evidence.
Who knows, even trial court may have passed some order. Of
He
if
is-
60 days has expired.
No, it is filed, Lordship, on day after tomorrow, day before yesterday, so probably not passed any order. Because of that confusion problem.
No, sometimes the courts will fix the date on the date of expiry of statutory period. So even it can even be by oral application. Even if order is passed, he may still be inside.
Yes. Take instruction.
Problem.
Yes, my lords. Under section 103, my lords, proceeded case, my lords, there, my lord.
All right.
Lodge
20.
May I please your lordship? It is a regular bail application. What I prayed your lordship, my lord, to call for the case diary, my lord, fixing and to make fix it on the reopening day.
Yes.
Twenty-nine.
May I please your lordship? Lordship, it's a charge sheeted case. Lordship's scanned copy of the TCR may be kindly called.
Yes.
And a short date after vacation may kindly be given. Obliged, my lord.
May I please your lordship,
Oh,
lordship, this regular bail application is filed. FIR is at lordship.
what is the offense? Offense is what?
BNS 69 also. CD may be called for.
Yes. Even CD call for say that as the first words instead of taking us to FIR and all that. Yes, CD.
17.
Please, your lordship. Here, FIR, lordship, may kindly see page 13, that vernacular portion, lordship. Here, both them, the victim girl and the present petitioner were having, lordship, some affairs, lordship, since long. And subsequently, she was forced to lodge the present case. Even I have made categorical statement that if this honorable court require, he can produce the recording also of that part where she was forced to lodge the present case, lordship. Lordship, may kindly see the FIR that since 6 months they were in relationship And since 2021, Lordship, that showroom was closed, and even after that, they were, Lordship, in relationship. And I am having some bank documents which I have subsequently received, Lordship. I could not annex in my petition, that the present petitioner was also financially supporting the girl also, Lordship. That all those transactions are there. Both are measured. Some relationship was there, Lordship, admittedly. The bank transactions which were, Lordship, given by the petitioner to the girl, Lordship. I have marks few of them, Lordship. Since 2021, he was financially supporting the girl, Lordship. There was no, Lordship, that video, Lordship, that already police is and nothing has been recovered, those type of allegation, Lordship. No photographs was there, Lordship. And in fact, Lordship, in the forwarding report, if your Lordship peruse that page 15, that he was sent to judicial custody, and regarding police remand also, that they have said that not required for police remand, page 16. Just before prayer portion, Lordship.
No, prayer for police remand is there in the forwarding report.
No, that is for judicial remand, judicial custody, and in the page 16, your Lordship will find.
No,
whether
page 16, requirement of police remand and reasons thereof, not required.
Not reaching. Page 16, Lordship, may kindly see. Just before prayer for portion, Lordship, requirement of police remand and reasons thereof, not required for police remand. Everything says nothing was there in his mobile, Lordship, and police also knows all these things, Lordship. And this is, Lordship, purely on due to pressure. I have stated in my paragraph 5, Lordship, that he can produce that part also, because when the girl was, Lordship, pressurized by the local people, she called the petitioner, and which record the petitioner recorded, Lordship, those conversations. In last part of paragraph 5, I have clearly mentioned, Lordship, that. In 6 years, Lordship, they were, since 2019, they were in relationship. They met in the showroom of the petitioner's brother. Subsequently, that showroom, Lordship, closed during COVID period, and they were still in relationship, Lordship. And even though she was not employed at that point of time, but he was supporting her, Lordship.
Teaser list is there, mobile, I think.
No, that Caesar list is not here, Lordship. He was arrested on 13/6/26.
Study will be required.
As per my instruction, Lordship, it is already
Section
seized.
59 of BNS is jail option. Sexual intercourse by employing deceitful means. The punishment is up to extend to 10 years, Lordship.
And she herself stated that she worked there since 19 to 21. And my instruction is also that since 21, lordship, during COVID pandemic, that showroom was closed, lordship. After that, she was not an employee, lordship.
Seizure of anything.
But that seizure list I have not received, lordship. Yes, one certified copy is there, lordship. May I please, lordship? Certified copy.
Criminal intimidation, that part is also there, lordship.
Little video recorder and everything has been seized, but we don't know what is there.
Yes. So that digital contents is required.
When were you arrested?
He was arrested on 13/6/26.
the
Lordship,
case
kindly
diary,
remain
Just 10, 11 days.
Yes. we need
14
the
days,
case diary.
lordship. Some protection also, because he was, there was
Protection now.
evidently relationship, lordship.
Have it before vacation bench then. Release the matter before the vacation bench. Later on. ওলাইছে নেকি হেৰি? তাৰিখ নাই? তাৰিখটো নিদিলে হ'ল।
Can it
Seven
have
or
two,
eight?
lordship?
7, lordship.
Two, lordship. Obliged.
May I please, your lordship? Lordship, FIR is at page 12, lordship. May I read, lordship? May I, lordship?
What is this?
It's regarding robbery, lordship.
And
Lordship.
CD?
Lordship, whatever, lordship, I beg to submit to me, lordship. What is going, lordship, on 12th July, lordship, my marriage is going to be held, lordship. Therefore, I am begs to submit, lordship. I begs to submit.
Yes, he'll not marry you now.
Lordship.
You are a dacoit.
No, lordship. The fact is different, lordship. Lordship, page number 12. Lordship. This is to inform you that yesterday at around 6 p.m., a person forcibly entered into my residence with a gun. At the time of incident, my son was present at the house alone. The person threatened my son and demanded almirah keys. The person looted cash and few duplicate ornaments from the almirah before fleeing the spot. Cash amount of rupees 2,500 approximately. The CCTV footage of the person is also available with us. This is the FIR, lordship. It was filed on 13/6, lordship. Now, lordship, page number 15, lordship. Forwarding report, lordship. So point number 1, lordship, ground of arrest, lordship. So may I read, lordship? Page number 15. Lordship, on 13/06/26, complainant so and so of Borbai Durasan Colony informed that his some unknown miscreant entered his house when his son was alone and looted cash and few duplicate ornaments showing a gun. Now, lordship, 11 thing is on second point, lordship. Similar modus operandi of crime was about to occur at Borbari, Kanchannagar on 18/06/26, where local persons of the area apprehended Tridip Das and handed over to the police with his belongings, which includes a toy gun, lordship. This is the allegation against me, lordship. What happened, lordship? I am from Sonitpur, Tezpur, Sonitpur, lordship. My fiancée, lordship, would be wife, lordship. She resides in Borbari, lordship. I came to Gauhati for marketing and went marketing for my marriage purpose, lordship. When I went to Borbari, lordship, to meet my fiancée, lordship, so I bought a toy gun for my nephew, lordship, and some other things also bought by me, lordship, for marriage purpose, Lordship. But some local person was on suspicion, me asked several questions and I could not satisfy them, Lordship. Then they assaulted
Allegation
me,
is you
Lordship.
entered the house of some.
No, Lordship. I never entered, Lordship. I am not that person, Lordship. Lordship. In the FIR, it is specifically mentioned that CCTV footage is there, Lordship, but nothing has been written about the CCTV footage in the Lordship forwarding report. I am not that person, Lordship. I came to Guwahati for marketing of my marriage ceremony, Lordship. I
CCTV
went
footage
to
will be examined immediately by the, because of there is.
Lordship. I
question
have
of
annexed the
Seven, Lordship.
integrity of the
Lordship,
item is there.
Lordship, the annexer, Lordship, the page number, Lordship, 23 onwards, Lordship, the marriage registration card, Lordship, is there, Lordship. My fiancée resides in Guwahati, Lordship. She is a teacher, Lordship, in a private school, Lordship. I went to meet her, Lordship, along with some things, Lordship, which I have bought, Lordship, for my marriage, and that toy gun, Lordship, I bought for my nephew, Lordship. It is not a crime to buy, Lordship, to have a, Lordship, toy gun, Lordship. But nowadays, Lordship, when some crowd gather, Lordship, some people became, Lordship, aggressive, Lordship. So thereby, Lordship, I was apprehended and police had involved me in this case,
No
Lordship.
reason people will just
No, not
apprehend you for
sometimes, Lordship.
nothing.
Sometimes, Lordship, it happens.
Well-
Sometimes, Lordship, not all the time, Lordship.
July, Lordship.
You're not
Lordship.
even telling the full story actually.
Lordship, my marriage is going to be held, Lordship, on 12th July, Lordship. I am
But
behind
you'll
the
have it
bars,
on-
Lordship. I am behind the bars, Lordship. Some interim bail may be granted, Lordship, then, Lordship. Interim bail may be granted, Lordship. Several things has yet to be done, Lordship, for the marriage ceremony, Lordship. Everything has been scheduled, Lordship, earlier, Lordship. Considering the circumstances, Lordship, it is very unfortunate,
Circumstances is that
Lordship.
because of your marriage, you needed ornaments and cash.
Lordship,
You
it is
total
very
ornaments
unfortunate, Lordship. It is very
and they're
unfortunate,
duplicate
Lordship.
also.
It's a very unfortunate, Lordship.
Unfortunate, yes.
My would be wife, Lordship. She is a teacher,
It is
Lordship.
unfortunate for the girl.
Yes, Lordship. It is, Lordship. Interim bail may be
You are unfortunate for the girl.
Lordship. At least interim bail may be granted, Lordship. Let the marriage to be solemnized, Lordship. Both the families are in tension, Lordship. It's a looted 2,500, Lordship, and duplicate ornaments. They are duplicate ornaments, and here
You thought they were real.
duplicate gun, Lordship.
Lordship, kindly fix it on 2nd of July, Lordship.
Such an interim bail, Lordship.
Because ground number 2nd, Lordship,
Huh.
page 15.
Yes,
Similar modus operandi of crime was about to occur at Borbari, Kanchannagar on 18/6/2006. That is a habitual offender, Lordship, where local people of that area apprehended Tridipdas and handed over to police with his belongings, which includes a toy gun.
Lordship. I have, Lordship,
With that
categorically,
Oh, you have a history also.
Yes.
All marriage is on 12th. Okay,
Yes,
we'll have it
12th.
on 2nd. You'll have 10 days to arrange.
obliged, Lord.
Night, please, Lord. This is a regular bail application, my lord. Petitioner is behind the bar since 20 days, my lord. The allegation is that, my lord, petitioner and others collected some money from the drivers and handyman of the vehicle, my lord. At this stage, CD may be called for, my lord. Immediately after vacation, my lord. 7, if possible, my lord, on vacation board.
Deeply.
Well, this bail was earlier rejected by your lordship at page 37 after going to the CD. Today, my lord, I am in custody for 47 days. Statutory period is 60 days. due to the my lord, incoming vacation and my lord, since nowadays even under statutory period where it is 60 days, the police custody can be taken only on the first 40 days. So my respectful submission today, my lord, that considering the length of detention, my lord, further custodial detention may not be necessary because they are will cooperate with the investigation and will ready to face the trial of the case, my lord. Your lordship's rejection order is there. My lord, I am not on the rejection that is at page 37. Brother has been granted anticipatory bail in he is on interim. He is one brother is inside jail for last today 47 days. Only on the period of detention, if your lordships may consider, because the statutory period is 60 days. And all the stolen goods have been recovered by the police, my lord. And the predicament was that they had taken, purchased those goods for 3 lakhs. That has also gone now.
It was rejected on 17/6.
Yes, my lord.
So
Today
not
is,
even 10 days have passed.
my lord, today is 47 and statutory period is 60 days. And it will be expiring during the vacation only, my lord.
Let's have it on
Yes.
second, vacation bench.
Yes, sir.
City.
We are deeply obliged.
Makes legal also. As on today, your lordship, 30 days behind the bar. The petitioner is a youth of about 25 years, your lordship. And FIR lordship will get at page number 11. There's some 5 accused, but I am only for one of them, Baponuddin Majumdar, your lordship. Page 11 is the FIR. FIR was lodged on 25/5/2026, and on the very same date, your lordship, the petitioner was arrested. The case that some online fraudulent transactions took place, your lordship, and the allegation against the petitioner is that some amount of money of about 3,50,000 was deposited in his account. He withdrew the amount and gave it back to the other persons, your lordship. That is the allegation, your lordship.
I think I have read this affair before.
Now, your lordship,
Review will be recorded.
now in this case, your lordship, all the offences that have been there, your lordship, they are below maximum 7 years carry imprisonment, your lordship. Now, as per the Arnesh Kumar, your lordship, in case of offences 7 years or up to 7 years, your lordship, there is a requirement of issuing a mandatory notice under section 35(3) of the BNSS, which is not done in the present case, your lordship.
We will find from the CD only.
Yes, lordship.
Lordship will kindly see, because the forwarding report I have annexed, your lordship. On the FIR was lodged on 25/5/2026, and on the very same date, your lordship, he was forwarded at page number 13, your lordship. Absolutely no, in the grounds or in the reasons, there has not been a single mention as to why a notice under section 35(3) BNSS has not been issued, your lordship.
Be mentioned in the case diary. But I think I have passed some order in a
Similar.
I'll just rely on a order of this.
Perhaps lordship similar. might-
because this name looks similar, Baponuddin, because
Baponuddin.
this FIR I have read before.
Yes.
Money was deposited in his account.
Against him, the allegation is that, your lordship, some amount was deposited
the
which he
case?
had withdrawn. Now, in this case, your lordship, this honorable court has held that if there is absence of notice under section 35(3) BNSS, then in the
First
interim,
establish that there is absence of notice or whatever.
no, your lordship,
That we can have from the CD only.
25, your lordship, and on the very same date, the arrest was made, your lordship. And it is a mandatory requirement that has been held by Arnesh Kumar, and recently again, your lordship, in Satinder
Yes.
Kumar.
What has been decided in Arnesh Kumar?
Lordship, I'll place the judgment, your lordship.
Does it say that In no case, arrest can be made without notice. It says follow 41.
Yes.
What does 41 say? For recording reasons, he can be arrested.
41 says what? Let us call for the case study.
No, so
I think you have not done your research. I am very sure that similar matter has been disposed of somehow, the same FIR.
No, Lordship, this is the Anesh Kumar judgment, your Lordship, I'll please. Section 35(3) notice is mandatory in case where offences is 7 years or less than 7 years, your Lordship.
Para,
Lordship, I'll come to. I'll just read your Lordship at page 279, para 8.3. That even the magistrate has to find, he has to.
first let's go to the police, then we'll go to the magistrate.
Lordship. In that case, your Lordship, para 7.2. Lordship has got it. The law mandates the police officers to state the facts and record the reasons in writing which led him to come to a conclusion covered by any of the provisions aforesaid while making such arrest. The law further requires the police officer to record the reasons in writing for not making the arrest thereof. In Pitan Co, the police officer before arrest must put a question to himself: why the arrest? Is it really required? What purpose it will serve? What object it will achieve? It is only after these reasons are addressed and one of the other conditions as enumerated above is satisfied, the power of arrest needs to be exercised. In fine, before arrest, first the police officer should have reason to believe on the basis of information and material that the accused has committed the offense. Apart from this, the police officer has to be satisfied further that the arrest is necessary for one or more of the purposes envisaged by subclause A to E of clause 1 of section 41.
So have you got it now?
From the grounds of arrest and from the reasons of arrest that has been there, your Lordship, absolutely no reason as to why this notice under section 35(3) has been dispensed.
Why is it to be mentioned there? Does it say that it has to be mentioned in that document? That is why we say CD.
And page 2,
Yes.
Your submissions have no legs to stand on. Yes, call for the CD.
Now, Lordship, in that case, Lordship has asked for the CD tomorrow, your Lordship. The similar matter has been fixed, your Lordship.
All right. If it is fixed, then why waste the time
Yes.
unnecessarily?
Let it
Could
be-
have said that at the very beginning.
No, because your Lordship, there is a violation of section 35. There is a violation of section 35.
List it before vacation bench.
Yes.
Oh.
There is a violation of section 35. That is why I have said, your Lordship. Let it be tomorrow, your Lordship. CD is fixed. on
Second.
tomorrow. Tomorrow, CD is fixed, your Lordship, on the similar matter, your Lordship.
Yes, next item.
Tomorrow, your Lordship. In this case, your Lordship, the petitioner is behind the bar with effect from sorry, with effect from 9/8, your Lordship. 9/6. And the both of he is behind judicial custody, your Lordship. Then notice under section 35(3) was issued, your Lordship. He appeared, and after his appearance, your Lordship, he was taken into custody. Now, Lordship will get the FIR at page number 11, your Lordship. Page number 13, your Lordship. Page 13 is the FIR, your Lordship.
Any reason why we should allow without seeing the CD?
Lordship, the incident took place on 2/2/2026, and after 6 days, your Lordship, he was transferred to Nagaon, your Lordship. After about 3 months of the offense, your Lordship, a notice was issued to him, your Lordship, on 2/6/2026. And on 8/6/2026, he has duly appeared before the IO, your Lordship, and thereafter he was taken into custody, your Lordship. Now, since he is already transferred, your Lordship, and as per the forwarding report, only judicial custody was sought for, your Lordship. Since he is behind judicial custody, your Lordship, and The offenses are less than 7 years, your lordship.
FIR reveals my lord, he has taken bribe from
I
the.
think we have heard this story before also.
Let him.
I have heard, your lordship.
Jail staff.
Yes, madam.
Yes, CD.
My prayer, madam, let it call for the CD, madam.
On who, your lordship? Application.
Not on 2. 14, my lord, 14 July.
Let it be on who, your lordship. Otherwise, the mandatory period is 60 days in that case, your lordship.
It will be the number of days on 14th.
Uh, it is
14th year.
Forwarding report 9/6, my lord.
Then that's less than 30 days.
It will be some 35 days, your lordship. And otherwise, they are only in judicial custody.
Yes,
Yes,
next
he
item.
has complied, your lordship. Obliged.
This case, my lord, someone is issued to me, my lord. That is apprehension if I appear before the learned trial court, my lord. I may put in custody. The case is that, my lord, it is, my lord, if your lordship go to the FIR, my lord, it is in the year on 9/6/2024. Before 2 years, one FIR was filed, my lord, saying that I was kept talking with that girl, my lord, the daughter of the informant. And for that, my lord, one day that girl has not reached on time at home after completion of tuition. So there was a suspicion that I may kidnap that girlfriend or whatever, my lord. Subsequently, FIR was lodged against 5 accused persons. 2 were arrested and 2 have been exonerated by the police during filing charge sheet.
So then there must be material against you.
My lord, in fact, my lord, if your lordship go through, nothing material is against me, my lord. Only there is a suspicion. Nobody said, even the informant who is described in the FIR, she is saying that there was a phone contact with that girl, my lord. May I read the FIR, my lord, first?
You must have got her statement. Where is that?
Daughter statement is not there, madam, because daughter refused to get medical treatment. Medical certificate I have annexed, madam.
But she was not examined by magistrate.
Not examined by magistrate, madam.
Where is that?
Examined by master, but daughter has not, my lord, implicated me, my lord, in that way.
Where is that?
That statement is not with me, my lord.
Then search case, it must be with you.
No. My lord, that statement is not with me, my lord.
Then you are.
Charge sheet, my lord,
That
may I
means
read
you are
this?
suppressing it.
Not suppressed, I have not, my lord, received that one, my lord. So
How
my
can you
humble
not receive?
submission, my lord, kindly go through the FIR first, my lord, kindly. What is the offense? What it is, my lord, aptly presumed that there is nothing specifically
What
against
is
me.
the charge sheet section?
Charge sheet section 366A, my lord.
He is the, my lord, accused number 1, my lord, crime accused, my lord.
I was
Against
kept,
allegation is there,
I was kept talking with that girl, my lord. This is the allegation only. And this is described in the FIR also, my lord.
As per
Page 12 FIR, my
We
lord.
had-
May I read for a moment FIR?
If you had annexed that statement, then we could have at least examined what your culpability. But okay, TCR.
on 20 July, my lord.
One submission, my next date, my lord. It is next date on 6/7/2026.
So many next that will go, you will not go anyway.
Bless. May I plead your lordship? Matter may taken after some time, lordship.
Back of this. Your lordship will find the FIR at page 21. After consideration of this FIR, my lord, your lordship has granted regular bail to all the person mentioned in the at page 21. And your lordship's order is at page 27.
Page?
Page 27. Page 27, your lordship has observed that I have perused at page 29, I have perused the bail objection filed by the investigating officer as well as the medical documents available in the case diary, wherefrom it appears that the victim did not sustain any serious injury, although some to the eyewitness have implicated the present petitioner. Having regard to the nature of injuries sustained as well as the nature of the allegation, further detention of the petitioner may not be necessary. So there was an objection from the IO, but your lordship considered the case diary and released the father. Now, the son, who is only 18 years, page 15, I have given his admit card. Now they are summoning him to the police station after the father's release, my lord. That's why we are before your lordship on a pre-arrest bail application. My lord, your lordship will look into this CD, but till the CD comes, your lordship will protect this teenager, my lord, who is just 18 years old, my lord.
It heard Mr. Learned. Page 27. or- The 482.
Page 27 is the father of the petitioner, my lord.
Permission that the CD may be called for, madam.
Yes.
For granting any
Nature 18 years, your lordship will protect till the CD, my lord. Because admissions for the colleges are going on. That's why I have prayed, my lord. And your
then-
lordship has seen from the CD prima facie, there is no allegation of any
There are
serious
1,
heart.
2, 3 main facts of the case. Order dated. Okay, 152026 accused. Granted bail. The perusal of the CD. Call for the. Provided in the interim that in the event. Of interim bail of is 50,000. Security for like amount. Arresting authority. Shall not try to. Take the victim or his family. Get page para 30, page 35. Please again.
Deeply obliged.
Appear before I within 10 days.
Yes, fine. I will go and pay. Obliged, my lord.
My lord, I have filed this petition for quashing the order dated, my lord. Quashing the complaint case, my lord, which is filed by the respondent, my lord. And that is the civil nature case, my lord, but they have filed a complaint case, my lord. And you see, my lord,
But for the respondent.
are the respondent. And this is the complaint petition, my lord. It is clearly mentioned, my lord, in page 7, my lord.
Everything, otherwise it is, everything is complete. Record,
No, my lord.
record not received.
Actually, my lord, I could not file the copy to her. I could not serve.
Huh?
the copy. She has, I have filed a petition, criminal petition. Sorry, I have filed a complaint petition, complaint case in the CJM court. Against this, they have filed one criminal petition.
So far we have understood.
I could not serve the notice. I have filed an affidavit. I could not serve the notice to her. Because the case is not true. Sir. There is
Affidavit,
something-
this,
Yes, so
I mean objection, you filed objection.
Objection, yes, I had an affidavit.
Right, scan copy of PCR is not yet received. Issue reminder. Submitted that written objection has been filed by the respondent. copy of the same be served upon learned counsel for the petitioner. The matter.
Yes. I have already served a copy, my lord, but they have not filed the objection, my lord, today.
Yes, my lord, I told.
Yes, yes,
I
next
did not
item.
file.
You go out and talk among yourselves. Yes.
August.
Main page, Your Lordship. I'm very sorry, my lord, I was in the other court, my lord. Well, before coming to the FIR, my lord, I'd like to draw your lordship kind attention to page 17, my lord. This is the FIR which was lodged by us, my lord. Page 17. Actually, my lord, we are contractual, my lord. We are doing a contractual work of my lord, drilling, my lord. In Tinsukia, my lord. This is the FIR lodged by us, my lord. It is on 14.5, my lord.
Which page?
Page 17, my lord. We have been doing a contractual work, my lord.
This is registered.
No, my lord, it has been received, my lord, page 19, my lord. It has been duly received on that day, my lord. But my lord, my lord, it has been, GD entry has been made, my lord, but it was on 14, my lord. Now, my lord, as a counter blast, my lord, there was a quarrel between, admittedly, my lord, because we are, my lord, doing a contractual work of drilling, my lord. Page 10 is the affair where we are seeking bail, my lord. Totally afterthought, my lord. It is on 35, my lord. Now, after the lapse of so many days, my lord, they have lost this affair, my lord. Nobody got injured, nothing, my lord. Only, my lord, they were disturbing our work, my lord, every now and then. And only to save their skin, my lord. And, my lord, to stop us, my lord, from working further, my lord, they have lost this affair, my lord. The informants were all named, my lord. The page 17 informants were also named. They are before your lordship, my lord.
So many injuries have been described here and you
But
are saying
these are,
nothing happened.
Stabbing and all, these are all, my lord. Nobody got injured, but nobody went to any hospital. There is nothing of that sort, my lord. Only, my lord, to stop us from working further, my lord. What I pray, my lordship may call for the case diary, my lord. If there is any injury, my lord, along with the injury, but lordship may reject my bail application. I will not utter a word, my lord. They are continuously disturbing. Only to refrain us from working further, my lord, they have lost this affair.
A separate incident, my lord, totally different from the.
No, but our incident, it is that, my lord, they have been disturbing us, my lord.
Several persons were injured.
No, but nobody were injured, my lord. Nobody went to the hospital, nothing, my lord.
But on the face of these allegations, how can we straight away give away protection? We
No, my lordship may kindly see, my lord, nobody was taken to any hospital. They have not written, my lord.
They have written Aditya Hospital, Tinsukia.
My lord, that is after, my lord, nobody, nothing happened, my lord. Lordship may protect us, my lord.
You can say that nothing happened.
Because, my lord, they have been continuously disturbing us, my lord. We have lost the affair on 14, way back, 14.5.
Okay, let's have it on second. No problem. Application bench.
Second, my lord, I may not be there, my lord.
Then CD will talk. You said you will not utter a word.
But lordship may kindly protect us, my lord, because, my lord, we will appear, will definitely, my lord, cooperate with the investigation, my lord. More after vacation, no. So lordship may kindly protect us, my lord, on any condition, my lord. Our affair is also duly received, my lord. Page 19, in the below, my lord, the signature of the officer in charge is there, my lord.
Lordship,
My father-in-law was stabbed 3-4 times in his head and fractured my mother's right hand by an iron rod. Several injuries, my lord, we can say this time.
The face of it, we can't grant interim,
Yeah, the
so
face of it,
you
my
have to
lord,
make arrangement for either 2nd or 14th.
Second. Okay, my lord, second, my lord, we will send someone. Oblige your lordship.
May I please, your lordship? Lordship, TCR has been received, your lordship.
Before starting by the learned counsel for the petitioner, my lord, I am for the victim, my lord. The TCR has already come, my lord. I will file the objection, my lord, since in the last Saturday also same incident was happened. Both the brothers went this kidnapped the girl again on the way to the school.
Learned counsel for the petitioner, TCR has been received. Learned counsel for respondent submits that he will file an objection to the present petition. There is allowed list again.
May I please, your lordship? My lord, earlier date may be given. I am a student, my lord. And my lord,
Already given earlier date.
July 21. Oblige me.
It is lordship. Today the matter has been fixed for the production of case diary, lordship. If the case diary is available, lordship may fix a date for hearing after week. It may be fixed, lordship.
Learned counsel for the petitioner and learned. It is received. You has submitted the CD. The matter immediately on reopening.
22nd, lordship.
All CD be retained till then.
May it pleases your lordship. Lordship, this is a regular bail application. The accused person petitioner is behind the bars for 57 days as on today.
What is the offense?
On the basis of just a presumption that his wife died under suspicious circumstances and the marriage having been solemnized 3 months prior, so he has been arraigned as an accused. The FIR is at page number 28. The FIR also doesn't specifically leads anything against the husband, that is the petitioner.
PM report is there.
Report is awaited, lordship.
Report came.
PM report is awaited or final opinion is awaited?
Final opinion is awaited, lordship. Otherwise, PM cause of death is yet to be ascertained.
What are the injuries?
Lordship, it's a case of detected to be poisoning, lordship. From the hospital itself, that it's a case of, it might be a case of poisoning. Fatal nature, and
Lordship,
so far as the inquest report is concerned, lordship, protein from the mouth is sin, lordship.
Lordship, may kindly come to page number 59. That is the.
There is the FIR.
FIR
is a
is
page
28. The FIR reads as, this FIR has been lodged by the sister-in-law of the petitioner. I most respectfully state that my sister, namely Shruti Roy, has been married to Rupak Sen, son of Sunil Sen, resident of so-and-so, since last 3 months. Today on 26/4/2026 at 11 AM, her husband informed my father that
Otherwise, what is there in the CD? Any prior,
lordship.
any history of?
no criminal antecedent as such. The petitioner.
No criminal antecedents, but
He's an educated person, he's an engineer.
Husband-wife cases, hardly there will be criminal antecedents. It is only after marriage that you become a criminal.
attending doctors in the MLC submitted before the Dispur police station has opined that the case of that is poisoning, homicidal nature, which prima facie indicates the commission of a
No, evidence of other witnesses, anything is there implicating him that
Lordship, because
Anything
it-
regarding their
it has-
relationship,
It has
anything?
happened within the four walls, Lordship. So that.
No, no,
cannot
any
be
that prior quarrel or anything of the demand for dowry, nothing.
For dowry is nothing, Lordship. For his Lordship, he is plausible, he has to give a plausible explanation as regard to the death of the petitioner because it has taken place within the 3 months of her marriage.
But that is by ingestion of poison.
Yes.
If it is by assault, then obviously has to give an explanation. But if it
Lordship.
is by poison,
Yes.
isn't the explanation self-evident? It
Yes.
can be by self-ingestion also.
Lordship, in the face, that there is on her face, Lordship, inquest report says there are some injury marks on her face, Lordship. That we have found. And also came out from her.
This final cause of death will be by poisoning. It cannot say whether it is homicidal or suicidal in case of poisoning.
Yes.
So we assume it is a case of poisoning since there are no other injuries as such capable of causing death.
On her face, there are injuries, Lordship.
Injuries capable of causing death are not there. So we have to proceed on the basis of whatever is available now instead of waiting for the FSL report. That is not going to confirm anything. So the query is whether there is any material to hold on to the petitioner other than suspicion.
Otherwise, no injury has been found, Lordship, on her person. It's a 90 days offense, Lordship. As on today, 57 days only, we have time to investigate the matter. Still in progress, Lordship.
Now, what is the progress?
Vacation court, Lordship. FSL report is yet to be examined. Independent witnesses are yet to be examined, Lordship. Relevant witnesses, Lordship, we need.
It's within four walls. Nobody will know anything.
Second, Lordship.
It is between four walls between the husband and
It's a
wife.
serious offense, Lordship.
Lordship,
Otherwise,
only that presumption in the
It's a grave
discharge
offense.
report also, nothing of that sort
because
that
it has
reasoning has
happened
come.
within the four walls, Lordship, because on the same, if it has happened on the same roof where the accused is also residing, so he has to give a plausible explanation with regard to the date of the petitioner, Lordship. Because a person lost her life, Lordship. That is.
Apparently, there is no allegation of dowry or anything.
Nothing, nothing of that sort.
No
No
motive is
domestic
there.
violence, nothing.
That is not there.
So
Only, Lordship,
57
only
days.
it would point towards suicide
Lordship.
for some reason, maybe some pre-existing
We need
reason
to
also.
prove relevant witnesses to substantiate the fact.
57
that
days
whether
have
he is
already passed
innocent or
by.
he is,
He's languishing in judicial custody. Even today, they want witnesses.
Second, Lordship, we may.
The only
Not to be
breadwinner in
twisted.
the family, his father is bedridden, 85 years old. The permanent resident of Gauhati. So there is.
Oh, okay, heard learned counsel for the petitioner and learned PP. Petition under, so the petitions briefly stated that the wife of the petitioner met with an unnatural death suspected to be because of poisoning after 3 months of her marriage with the petitioner. The CD has been received along with the postmortem report, but the final opinion regarding cause of death has not been mentioned due to non-receipt of FSL report. The petitioner was arrested on
27/4/2026.
since then has been languishing in jail for how many days?
57 days as on today.
57 days. Result of the FIR, which was lodged by the sister of the deceased, does not indicate any act of cruelty or any demand for dowry having been made by the petitioner, and it appears that the same was lodged on the basis of suspicion. Submitted that the father of the petitioner is 85-year-old bedridden person is required to be taken care of by the petitioner. Other material available in the CD does not attribute anything illegal to the petitioner. However, having regard to the seriousness of the allegation at this stage, the final opinion as to cause of death may be awaited. And till then, the petitioner may be released on interim bail. Accordingly, it is directed that the so shall be released on interim bail of ₹1,000 with a surety for like amount to the satisfaction of the law. Like a magistrate. Again, after vacation, send the CD for resubmission along with final opinion as to cause of death.
Deeply obliged.
Please, your lordship. It is a regular bail application, my lord. The prisoner behind the bar for 82 days as on today, your lordship.
CD.
Is your lord CD was called for, earlier occasion CD was called for, perhaps it is not.
My lord,
received.
CD, my lord, as per CD, he is not, item 20.
20.
He did not receive, my lord, in this case.
Not. It is a 90 days, total period is 90 days, your lordship. It will be done during vacation period. P7. Further detention is not necessary, your lordship. I'll face trial and I'll cooperate the IO, your lordship. Granted in any condition, your lordship. FIR is at page 9, your lordship. Particular, your lordship. Page number 9. Earlier, it was rejected by sessions of your lordship on result of CD, your lordship.
Let it come before vacation bench.
Second, my lord.
Second. She did not receive, please before the vacation bench on second.
Please, your lordship. Lordship, it's a regular bail application, lordship. The accused has been behind the bar since last 49 days, lordship. The Azahar is at page number 31, lordship. At page number 29, lordship, Azahar. This is to inform you that some false students have applied for Ishan Uday scholarship, falsely claiming that they are enrolled in different courses under ITM Mazuli Bongaon. It is hereby stated that some no such courses exist in our institute and the students are not enroll in any such program. The claims.
Yes, what is his role, this Khogan?
So he is the nodal officer, Lordship,
Nodal officer of?
that Lordship, that.
What?
Lordship. KYC registration, Lordship. That is Lordship.
What role is attributed to him?
That is not reflected, that is not come out, Lordship, because Lordship, only that he was appointed by one Mr. Girish Chandra Kolita, and that person was not yet been arrested. And now this person has stated that he is no way involved in this case, and he do not know how his name is being incorporated as nodal officer. This is searching that Girish Chandra Kolita, but this person's Aadhaar card and all details are also put in the that online system.
So no clear role is available. Guard Learned Counsel for the petition and additional PP. This is an application under so and so. Paragraph 2. The petition.
Sorry.
Sir, breaks to state nalage aro. 123 to 26 বুলি আৰম্ভ কৰি আনন্দ চন্দ্ৰ শইকীয়া চাগে তাৰে পৰা কি গ'ল The petitioner was arrested on when were you arrested?
7th of May.
7/5/2026 and since then has been behind bars for about 47 days.
He was forwarded on 8/5.
About 47 days. Perusal of the CD learned LPP. It's that there is no specific role discernible from as regards the present petitioner. Upon perusal of the material available. So, having regard to the above as well as the period of detention. Therefore, bail is allowed. 50,000, 2 securities.
Deeply obliged.
That is Lordship. Similar matter, item number 31, Lordship, arising out of the same CD. That's why same affair, Lordship. 31.
He did not available, Lordship.
This is the second time, Lordship. Kindly come to the FIR, Lordship, page 10. Page 10 of item 22.
Item 22, 10.
10. May I?
Yes.
মহোদয় সন্মানপূৰ্বক বিনীত নিবেদন এই যে মোৰ ভাইটি আকৰাম আহমেদ আজি ইংৰাজী 23/5/2026 তাৰিখে পুৱা প্ৰায় 9টা বজাত শিয়ালমাৰী কুটিয়ানী বজাৰত বজাৰ কৰিব গৈছিল সেই সময়তে উক্ত আসামীসকলে ষড়যন্ত্ৰমূলকভাৱে 1 নম্বৰ আসামীজনে লগত অচিনাক্ত 3জনক লৈ হাতত চোকা অস্ত্ৰ লৈ হাতুৰি চুৰি আৰু আঙুলিত লগোৱা ফিংগাৰেৰে মোৰ ভাইটিক মূৰত আঘাত কৰে যাৰ বাবে মোৰ ভাইটি গুৰুতৰভাৱে জখমী হৈ বৰ্তমান বৰভেটি নেমচি হস্পিটাল চিকিৎসাধীন হৈ আছে Lordship, there is no role on my part, Lordship, in this affair, Lordship. Kindly,
your name is?
My name is Sadir Ali. Sadir Ali, father of the accused person, Washim. The 1 number Asami is the Washim, Lordship. In the affair itself says that 1 number Asami jone logot osinakto 3jonok loi. I was not there. As because I'm father
Is
of
any injury report?
CD not received.
Not received.
Lordship,
How many days?
I have 30 days, Lordship. I am 54 years age, Lordship. And the second time CD was called, but police did not turn up, Lordship. And 1 month time is enough for investigation. There is no need for my detention. And the other two cases, lordship, the main accused is on interim bail, lordship.
Then the WT message that IO is on training.
He's a known person.
Lordship.
Are the parties known to each other?
Yes, lordship. The neighboring village, lordship. And that's why my name.
Then if his father was present, then he would have been named in the FIR. Third, counsel for the petitioner and PP. This is an application under brief of the case. Brief facts of the case is that forwarding report page 11, brief of the case. Error is submitted by learned counsel for the petitioner that the petition informant side, the petitioner side are neighbors and all are known to each other, but yet the present petitioner Sadir Ali, who is the father of the main accused,
Wasim,
him, has not been named in the FIR, and instead it is stated that some unknown persons were present with the main accused when the incident took place. CD has not been received. On perusal of the forwarding report, including the grounds of arrest, is seen that only wrongful restraint has been mentioned therein. There is no indication of any grievous injury having been caused. Having regard to the above as well as the period of detention, the prayer for bail is allowed 50,000 to sureties. Same, who is to end this other item?
Other reason for anticipated bail, lordship, to the main accused Wasim and his mother. We are on interim, lordship.
They are on interim.
Yes.
All right. CD not received list again on so and so. In order to continue till next date of listing.
Next date. Next date.
After vacation.
Take this matter after some time.
My lord, kindly, my lord, here in this case, my lord,
Received.
here in this case, my lord, some property dispute, my lord, and both the parties, my lord, lost cases, my lord, lost cases are there, my lord. And FIR itself, my lord, stated, my lord, there is a, my lord, property disputed. And as per my instruction, my lord, both the parties, my lord, sustained some minor injuries, my lord. And cross cases are there, my lord. I have annexed the land documents also, my lord.
It is too early actually. Because of your insistence, it was listed today, I think. It was only on 19th. In 7 days. So you a chance it did not come. So wait.
2, my lord.
All right.
Obliged. My lord, kindly both the case diary, my lord. Cross cases are there, my lord. Both the
It
case.
is required, lordship, because lordship that will be decided on the basis of their case diary, lordship. Calling all those
No,
citizens.
my lord, both the cases are required because cross cases are there.
Then you will have to wait till the coming of the reopening.
No, my lord, at two, my lord.
Please, your lordship. If the FIR is in page 14 and 15, lordship.
Receive. The report is there.
Medical report is awaited, lordship.
What is the point of the CD without the medical report? This is a case of injury.
Otherwise, admittedly, the accused himself admitted the fact that he has assaulted the person with a sharp weapon, that is cautery, lordship, one kukri. And that kukri has been seized the place of occurrence, and scissor list is there. And lordship, there is also eyewitnesses.
Anybody saying about any nature of injury caused?
Lordship, the boy who was assaulted has been roaming here and there and
May I read, lordship, the statement? Accused Arup Das, ক'ব লগা এই যে ৰাতি প্ৰায় 9টা 9:30 বজাত মই ঘৰৰ সন্মুখত ৰাস্তাত এখন কটাৰীৰে তামোল কাটি আছিলো, তেতিয়া মোৰ ওচৰলৈ আহে আৰু কিবা কিবি কয়। তেতিয়া মই অলপ নিচাত আছিলো আৰু খঙতে মই মোৰ হাতত থকা কটাৰীৰে তাৰ গালৈ ঘপিয়াই দিয়াত তাৰ পেটত আৰু আঙুলিত কটা যায়। মই তাক বাধা আৰু মই তাক মাৰি পেলোৱাৰ উদ্দেশ্যৰে তাক কাটা নাছিলো। And same sort of statement has been given by the Caesar witness. আজি ইংৰাজী 26 তাৰিখে ৰাতি 9:30 বজাত আৰু আমাৰ গাঁৱৰ অৰূপ দাসে ঘৰৰ ওচৰৰ অনুৰণ দাসৰ লগত ৰাস্তাত কিবা কথাত তৰ্ক বিতৰ্ক কৰে আৰু অৰূপ দাসে হাতত থকা এখন চোকা কটাৰীৰে তাৰ পেটৰ তলত আৰু বাওঁ হাতৰ আঙুলিত ঘাপ মাৰি কাটি দিয়ে, ফলত অনুৰণ দাসৰ গুৰুতৰভাৱে জখম হৈ তেজ ওলায়। And those sharp weapon has been seized from the place of occurrence. Accordingly, seizure list is prepared.
Lordship,
He has been
actually-
admitted, and the victim statement is also there, lordship. And
What does the victim say about his injury?
yes, lordship, I'm coming to his statement. অৰূপ দাস ঘৰৰ সন্মুখৰ ৰাস্তাত থিয় হৈ থকা সময়ত মই ঘৰৰ পৰা ওলাই আহি তাক দেখা পাওঁ। তেতিয়া সি তাৰ ওচৰলৈ মোক মতাত মই তাৰ ওচৰলৈ যোৱাত সি মোক কিবা কিবি কথা কৈ মোৰ ওপৰত খং কৰে। তাৰ হাতত থকা তামোল কটাৰ কটাৰীৰে মোৰ খাপ মাৰে, ফলত মোৰ বাওঁফালৰ বুকুত আৰু বাওঁফালৰ আঙুলিত কটা যায়। সি লগে লগে ঘৰলৈ পলাই যায় আৰু মই চিঞৰ বাখৰ কৰোঁ। তেতিয়া মোৰ মা দেউতা আহে আৰু মোক হস্পিটেললৈ লৈ যায়।
The kukri has become a tamul kata kotari.
তামোল কটাৰ কটাৰী, yes.
Lordship, the statement of the victim and the FIR is slight contradictory because in the FIR, the informant stated that they were standing before their residence and not in the residence of the accused, Lordship.
When were you arrested?
I was arrested on 6/6/2026, Lordship. But the thing is that altercation happened between both the parties there. And in between that altercation, when the boy got pushed away and some scratch marks were scratch
Red
marks
Heart Learned
happened.
Counsel for the petitioner learned additional PP. An application under so and so. The brief allegation is that the petitioner, because of a quarrel, assaulted the victim with a pottery. Petitioner didn't quote. As a result of which he sustained serious injuries. Where the CD as called for has been received, but the medical report is not available. However, on a perusal of the statement of the victim himself, it does not appear that any grievous injury was caused. Para having regard to the above as well as the period of detention of about 19 days. The prayer for bail is allowed 50,000 to sureties.
Obliged. One.
For some time.
Eight piece advantage. The PCR was called for on the last date.
Here not receiving 52.
Otherwise, Lordship, around 110 days in custody.
The offense.
Abatement of suicide, Lordship, will find the FIR at page 12. Admittedly, there was a romantic relationship between the accused and the deceased. What has happened, my case, Lordship, is that ultimately the death happened in her father's house, that is the complainant's house. And there is some difference between the time. Lordship, if I may place the FIR at page 12. Was in my house on 27th, Lordship.
Where is the FIR?
Page 12. The type for. May I read? Lordship? Witnesses, Lordship. Trial has not commenced as yet. There are 12 witnesses. Trial has not commenced as yet.
Yeah, call for my office.
Lordship will have
Under
page
section
43.
108, my lord.
Page 43, Lordship. The witnesses in the charge sheet. In custody from 10/6, Lordship. 15/3, Lordship.
All right, I think enough.
Yes,
110 days.
Yes. Parents have been released on anticipatory bail, Lordship, the co-accused. He's behind the
He is the prime accused man.
Love affair. Had it been a wife, I could have understood in the house, but she herself went to the house and then she got tortured. Story doesn't look very convincing.
After, my lord. Died.
And she was in her father's house.
Yes.
Died in the house.
Lord.
She was not taken to hospital.
For a substantial period, Lordship.
Third learned counsel for the petitioner. Third additional PP decision application under so and so. The allegations as revealed in the FIR, briefly are that the victim, aged about 25 years, was in a love affair with the petitioner for quite some time. And what is the FIR page?
Page
Lordship,
12, Lordship.
page 12, Lord.
12 is the translated.
Indian law of affair with the and when to continue and during this period the petitioner used to torture the victim mentally regarding the love affair, because of which she was forced to go to the house of the petitioner on 27/01/26, where she was again tortured. Stop unable to bear the torture, victim consumed poison the house of the petitioner and fell ill. He was taken to hospital by the petitioner and after treatment was handed over to the informant stroke father of the victim. But the victim again became ill at her father's house and subsequently died at around 1 p.m. next day. And copy of TCR has not been received. The parents of the petitioner have already been granted the privilege of pre-arrest bail by the learned Sessions Court. It would appear that after being treated at the hospital, the victim had gone back to her father's house and she died only on the next day at around 1 p.m. after becoming ill. And she was not provided medical treatment by the informant self, which could have possibly saved the life of the victim. There also does not appear to be any proximate instigation amounting to abetment part of the petitioner as per the contents of the FIR. Having regard to the above as well as the period of 110 days in custody gone by the petitioner.
24 days.
Further
24 days.
124 days. Further detention is necessary for the 50,000 to sureties.
Deeply obliged.
Item 51.
Yes.
This is a POCSO matter, Lordship. Section 10 of the POCSO, Lordship, and 74 of the BNS. Although it was initially Section 8, but the charge was framed under Section 10 of the POCSO. But 3 witnesses have already been examined, including the informant and the victim, Lordship. And my accused petitioner is in custody for today 343 days, Lordship. He is a teacher, Lordship. Charge was framed on 11/9/25, and till today, only 3 witnesses has been examined. That is up to 20th of April 2026, Lordship. Thereafter, Lordship, 4 or 5 dates were fixed for evidence. No further evidence has been taken, Lordship. So.
Where is the victim's evidence?
Lordship, victim evidence is at Lordship page number 32 to 36, Lordship.
What she has stated in her deposition at section 6.
Lordship,
The case for alteration of charge. Insertion of fingers, section 6 will be attracted more than once.
Lordship, so far as the incident of Tezpur is concerned, that is out of the jurisdiction of this particular court, Lordship. And that too, Lordship, that was the alleged incident of the Holi, that was in the month of March 2025. And the FIR has been filed in the month of July 2025. And moreover, Lordship, the victim has stated that she has not stated her mother, the PW2, about the case. Rather, she has stated one baby Mahi, Lordship. But the mother has filed the FIR, Lordship.
Because
And
Mahi
she has
will
also-
not file the FIR.
Has also yes, she has also stated in her thereafter, Lordship, in page number 34, Lordship, she didn't tell anybody, Lordship, about the incident. That was also there, Lordship. Lot of contradictions are there, Lordship. That apart, Lordship, he is a teacher, Lordship, and he is a ailing person, Lordship. Lot of these ailments are there. The jail authority has already taken him to GMCH and Nagaon Civil Hospital also, Lordship. He is behind the bar for 343 days, Lordship, and there is no chance of any tampering of his evidence. He is already under suspension, Lordship, and this girl is not in that school, Lordship. She has passed out and she has been admitted in another school, Lordship. And she has, during her cross-examination, she has stated, Lordship, she has been doing well. She has been singing Bihu songs and other songs as well. So physically and mentally, she was not being affected, Lordship. So his release will not affect, Lordship. He will abide by any conditions, Lordship. He will face the trial, Lordship. Under these circumstances, Lordship, and for last several days, for last several months, no other witnesses have been examined, Lordship.
For what reason?
Lordship,
What reason?
we are always present, Lordship. The witnesses are not coming, Lordship. On 24, 26, this on last witness was examined. On 4, 5, 26, no witness. On 18, 5, no witness. On 35, no witness. On 12, 6, no witness, Lordship. We are already this behind the bar,
Not
Lordship.
several months, 7 days, maybe not several months, Lordship. 2-3 days, maybe, yeah, Lordship. Lordship, may kindly go through the TCL, Lordship, and Lordship, yeah, Lordship, she is constrained, Lordship, what she has stated in one ATT statement as well as PW2, Lordship. So a 10 years old, 10 years baby girl, Lordship, see, there may be some contradiction, Lordship, but that may not be counted because, Lordship, what her state of mind, Lordship. And Lordship, that medical and all the issues that will be looked into by the jail authority, and that are taking care of, Lordship. So Lordship, and whether there is a scope of acquittal or not, Lordship, that has to be looked into, Lordship, because Lordship, there is a clear case. This is the victim is specifically implicated, and there is no any to my what I have gone through, Lordship, there is no any contradictions, Lordship. And even if some minor contradictions are there, that may not be looked into, Lordship, because a 10-year baby, there may be some exaggerated, some contradictions, Lordship. But whether that is material or not, Lordship, because
But in cross, Lordship,
180 statement, Lordship, but cross, Lordship, that will come,
he has
Lordship.
stated
But
that
what
only
he
bad stuff
stated
in
1 year after, before and 1 year after, that is constant, Lordship. That has to look into, because 10 years baby, Lordship.
That will cover what?
But Lordship, no, Lordship, so far as certainly it will be contained, but
They will examine. Let us see.
Your Lordship, I will add here. Your Lordship, the statement of the victim
Stand up a bit little earlier. We forget you were there. Before we close it, yes,
I'd like to mention because
yes.
the learned counsel is submitting that 3 PWs have already examined victim. She has mentioned on Gita. Until and unless that person is examined, your worship, I think that she seems to be a material.
First reported. See, eventually it is the victim statement that must stand, then we'll examine.
Obliged.
Please, your lordship. Lordship, in the instant case, CT has been received from the office, lordship, and lordship, I have been booked under section 310 subsection 4 of the BNS, that is preparation for committing dacoity, lordship. And admittedly, I am not the FIR named accused person. The main accused, the FIR named accused person has already been granted bail by this honorable court the day before yesterday, lordship. And as of today, lordship.
Where is the FIR?
FIR is at page 14, lordship.
14.
May I read the FIR, lordship?
For that fire station fellow.
Yes. Lordship, I am not the FIR named accused person. And today, as of today, it is 21 days in custody, lordship. And admittedly, no such recovery of incriminating objects, weapons, nothing has been recovered from my
You
possession.
have the order.
Yes, lordship, I have the order of both the co-accused. Three of the co-accused has already been released on bail. 3 of the co-accused.
That's may kindly come to NXRD page 25, my lord. This is the materials against him, my lord. The petition. Page 25.
Of
From-
this Annex D.
NXRD, lordship,
This memo.
clause number 4, my lord. During the, it is revealed that Sri Parag Jyoti Soike along with other associates has visited the target location for conducting vigilance surveillance prior to the proposed commission of Gauhati. Came to light that they had used one Tata Safari vehicle, number such and such, for the said purpose. Subsequently, it was recovered and seized, and he is the owner of that Tata Safari.
Lordship, if upon search of the vehicle, if anything incriminating objects was recovered, I went to the place of that day
Buy
along.
land.
Lordship,
Buy a piece of land.
along with my co-accused, the fellow who has been arrested. Lordship, there is nothing apart from this. There is nothing on. And admittedly, Lordship, he was after registration of the alleged FIR, he was arrested on. He was apprehended on 3/6/2026, and on the same day itself, he was forwarded before the learned magistrate court, which implies that there was no such interrogation or any other investigation done. He was straight away forwarded before the learned magistrate.
Going forward also, my lord, then again they will come back not
At
forwarded
least
within.
reasonable time should have been taken to interrogate him or any other incriminating substances that
Otherwise, my-
brought on
there, my
record,
lord.
lordship.
You were arrested on the same date.
Same day, 3/6/2026.
Yes, sir.
Receive the information as it is not,
What? I forgot. What was it?
it was filed or not, that is. Accordingly, we have taken the
What was not filed?
Sit was, sir, sit
Not filed.
Instruction was sought for.
Oh, that one, 63 days. Alternate counsel for the petitioner. PP. This is an application for regular bail to the petitioner in connection with so and so case. The petitioner was arrested on 23/4/26 and was produced before the magistrate on the same day, and by now has spent 63 days in custody. A statutory period of detention stated to be 63 days, 60 days. And upon instructions received, learned additional PP has submitted. The charge sheet has not been submitted as yet. The petitioner is entitled to default bail. It is directed that the please on bail of rupees 50,000 with securities of like amount to the satisfaction of the learned Ilaka magistrate. Hence disposed of accordingly.
That please, your lordship. So, for regular bail application, lordship. In this case, lordship, the petitioner is a head teacher of a madrasa, lordship. Lordship, I am coming to the fact, lordship, and the forwarding report will find page number 6. Sorry, FIR will find page number 11, lordship.
Image of my 12 years, my lord, 183 your lordship, early payrolls, my lord.
But the fact is, lordship, and I am very specifically stated in my petition, lordship. Kindly come to page number 5 in para number 5, lordship. There are some other person, lordship, had conspiracy against the petitioner, lordship. Otherwise, lordship, and if there is any medical will be there, then it will be revealed, lordship, if anything.
Yes, you are submitting.
Lordship, para number 5, lordship. The lordship, and the madrasa is there is the one building is construction is going on, lordship, and there is the body, lordship, constructing body, lordship, and one more person, lordship, they are demanding some money from the construction fund, lordship. In this regard, lordship, one conspiracy is set against me, against the petitioner. And Roman 2, lordship, page number 6, lordship. And few days ago, lordship, the victim and his other two classmate, lordship, stolen some money from the office, lordship, by breaking the almirah, lordship. And subsequently, lordship, the teacher and other teacher and bodies take decision, they will be ousted from the school madrasa. And in this regard, lordship, that is already been subsequently settled, lordship. But Roman 3 lordship, there is the madrasa lordship and common hall lordship, and more than 105, about 105 students is their lordship, and 3 hall lordship, and 9 teachers, 9 numbers of teachers. They are staying lordship. 3 teachers is permanently staying in the hostel lordship, and subsequently lordship. And on 13/5/2026, lordship 7 to 17/5/2000, he was out of station lordship. So, my lord, the allegation is made against the petitioner lordship. Victim does not disclose as per the FIR lordship prior to incident about 1 week back lordship. But he never disclosed anybody, even than his well-wisher or the classmate or his guardian's lordship. But the other person lordship, this false rumor is then, and subsequently on humiliation lordship, this FIR has been lost. And lordship, the fact is truly lordship, and I have stated as per the instruction lordship. But otherwise, there is nothing lordship. And one medical report lordship I have annexed in page number 18. There is nothing found any lordship immediate after closing the affair. There is not found any mark of injury, something else in his private part, lordship. But apparently, lordship, and he is about 15, 16 years he is doing as a teacher on this said madrasa. There is no any other adverse against him, lordship. So as on today, lordship, 35 days in custody, lordship. At any condition, lordship may be imposed, lordship. Otherwise, there is no chance of absconding, lordship. Waiting from that. And my submission may be recorded in the lordship.
Yes.
Listen for the informant man.
Lordship, regarding his travel dates, Lordship, as per their statement, it is from sorry, Your Lordship. As per their statement, it is from 13th of May to 17th of May. And the date of FIR is 28/5/2026. So in the FIR, it is clearly mentioned that the incident has happened 1 week prior, which the date comes to 12/5/2026. Also in the medical report, Lordship, though it is said that there is no violent mark or injury seen, for the recent sexual intercourse, it has been sent to higher central government. Also, it is not possible to have any injury marks because the incident is of 1 week prior to the reporting, Your Lordship.
Victim never disclosed anything, lordship, and if happened such type of incident, lordship.
Out of shame,
In the FIR, lordship,
there are so many hidden incidents which are never reported.
but the FIR is not FIR is silent, lordship, that part, lordship, and if there
It's
is
not an encyclopedia.
and even then his mother is there, lordship, the another person is lost this FIR, his one name, but not mother. And
Learned counsel for the petitioner.
the length of disorder may be considered.
He also heard. So respondent number 2, informant. As per in the fire, the is the your what, headmaster
Headmaster of the madrasa, lordship.
headmaster of a madrasa did penetrative sexual assault upon the victim aged about 12 years, who is a 12-year-old boy and a nephew of the petitioner, student of the said madrasa. Full stop. Error. So the petitioner submits that the present FIR is motivated by different reasons which are mentioned in the current application, namely one, of the petitioner to allow payment of rupees 50,000 from the construction fund.
Informant is demanded 6 lakhs now. I am very categorically mentioned in my petition. Para number 8, lordship.
Thereafter, month of April 26, the victim and his classmates stole some money from the madrasa and were caught red-handed. The decision was taken to expel the victim, the other students, but on the request of the guardians, they were let off with a warning. It is also stated that the informant side is different, demanding rupees 6 lakhs from the petitioner to compromise the matter. Perusal of the material available in the CD of the, including the statement of the victim recorded by the magistrate. Sufficient in the petitioner. Having regard to the serious nature of the, also the fact that the petitioner, the principal of the madrasa where the victim was a student, therefore in a position of trust. Therefore, bail is rejected at this stage.
Medical report, my
Deeply obliged, Lordship. Obliged.
Please, Your Lordship. It's a regular bail manner. The petitioner is behind the bar for 72 days manner. Diary was called for. Lordship, have a kindly look at page 19, the forwarding. Page 19, man.
Yes.
My lord, brief facts of the case, my lord. That on 4/4/26, a written complaint was received from Nijamuddin, son of so-and-so, my lord, stating that on 3/3/26 at about 8 p.m., the complainant younger brother, namely Ashikul Haq Borbhoya, went to the field of paddy land situated towards the eastern side of his house at so-and-so area for catching fish. After some time hearing his cries and shouting of help, then the complainant, other elder brother Farukuddin and nephew so-and-so rushed to the place of occurrence. That is the paddy field, and thereafter they also started swimming and shouting. Subsequently, the complainant reached the place of occurrence and saw that Farukuddin, Hussein Ahmed were lying on the ground in a seriously injured condition with bleeding. At that time, when the complainant raised alarm, the accused person advanced towards him with weapons and threatened to them. Being frightened, he shouted, "Save, save," and by lighting a torchlight, he was able to identify the accused person named in the FIR. Meanwhile, the local people started gathering at the place of occurrence. Thereafter, going a little distance from the place of occurrence, the complainant saw the dead body of his brother, Ashikul Haq Borbia, lying on the spot of the field, paddy field. Later, when Gumrah police was...
Who are you?
My lord, I am the named FIR accused person, but Lordship may kindly see the grounds of arrest number 1, my lord. The accused Jalaluddin is the FIR accused person who is found to be indirectly involved in the commission of the crime in murder of the deceased, causing grievous injuries and of 2 injured persons. Next, my lord, during investigation, it is revealed the accused had prior knowledge of the occurrence to this heinous crime and had shared common intention with the main accused person who are now evading after commission of the offense. Police has said, my lord, indirectly involved. Diary will reveal, my lord.
Lordship, I'm for the informant. Yesterday, Lordship has rejected four of the co-accused bail, Lordship, in this case. Yesterday, Lordship.
Diary, Lordship, sir, look at the diary, my lord.
Your baby is stillborn. Your baby is stillborn.
My lord, only the thing is that indirectly involved, my lord. I think, my lord, I think he is not involved in the commission of the offense, my lord. And prior knowledge only says that he had the prior knowledge of the occurrence.
Your order is there, but last.
Last order is not with me, Lordship. Fine, Lordship.
Hello, Kalir order আছে. Same affair. Yes, sir.
Madison Naiba.
Actively involved.
Actively involved in murdering or what?
Murdering.
Compala PCD section.
Yes.
I leave it to you, Lord.
Yes. Next.
I'm obliged.
May I please, your Lordship? Lordship will find the FIR on page 12, Lordship. The allegations are under section 140, which is kidnapping, 304 snatching, and 64 punishment for rape, Lordship. May I read the FIR, Lordship? Page 12, Lordship.
Yes.
Yes, Lordship has got the FIR, Lordship.
Hmm.
Lordship, in FIR, there are three parts of allegation. One, first of all, the allegation of rape. Lordship, other, the snatching of gold earring and silver ankle. And the third part is payment of money through, Lordship, online Google Pay, Lordship. Lordship, subsequently the case has been charge-sheeted, and today it is 189 days. And as after charge-sheet, Lordship, total there are 4 witnesses, Lordship, in this case. Only the charges have been framed now. Lordship, if Lordship has gone through the FIR, there are total 14 days of delay of lodging this FIR, Lordship. And the statements of the witness, total 4 witness, Lordship. One the victim herself, the other Baharul Islam, another Nazrul Islam. And both the independent witness claims to be the brother of the victim, Lordship. Lordship, victim has although implicated the present petitioner, Lordship. But if Lordship goes to the charge sheet, Lordship, where the particulars of prosecution witness has been listed below that, Lordship, Lordship will find that no medical examination has been done, Lordship. It is there in the TCR, Lordship. Result of laboratory analysis and expert opinion, medical examination nil. There are 2 other things, Lordship. Particulars of documents cited relied upon nil, Lordship. List of articles, material objected relied upon nil, Lordship. In the FIR itself, the victim has stated that the payment has been made through online mode, and we have proved a screenshot of the transaction, Lordship. The other witness, which is Baharul Islam, he says that the payment has been made by him. And as per the FIR, the victim says the payment has been made by Nurzul Mondal. And the other witness, which is Nazrul Islam, he says the payment has been made by Sahid, Lordship. All the statement does not corroborate with the victim statement, Lordship. No medical has been done, and neither the victim has protested to the charge sheet when the charge sheet was filed, Lordship. She herself has stated that there are screenshots, and other witness says that Baharul says that he himself has made the payment. The other witness, which is Nazrul Islam, he says that one Sahid has made the payment, and the payment has not been made to me. It has been clarified in the statements of those witness, Lordship.
Yes.
Here, 183 statement is not here, but only thing the charge sheet has been laid down and charges are framed, my lord. And charges are framed under section 64(1), that is rape, my lord.
Yes.
So I pray, my lord, let the victim be at least examined, my lord.
Lordship, there is no chance of manipulating or tampering, as there is no medical record, Lordship. And none of the witnesses corroborated, Lordship. And I am not the one who
Next
has,
date is fixed for, my lord, evidence, my lord. So
neither I am the person who has received
No,
the
there is every scope for manipulating the victim.
victim, my lord.
as there is no medical record, Lordship. There is
Unnecessary.
no medical receipt.
How old is the victim?
As the Lordship, victim age is 38, Lordship. And
What
other two co-accused are already on bail, Lordship.
What medical? Other
Otherwise-
accused on default bail.
Default bail.
Default bail, my lord.
Default bail. I'm not clarity, Lordship. And otherwise also other witness statement does not corroborate, Lordship. Regarding the payments also,
Those are not the charges.
No, these are not the charges, my lord. Main charge is, my lord, 64(1).
There has
my lord,
been
that
de-
is
there has been delay of 17 days, Lordship. And she states herself to be a daily wage laborer, where the FIR, she has been, the way the FIR has been typed, Lordship.
183 statement is not there.
not here, my lord. And the CD part is also not here, my lord. Entire
Then
CD
what is there?
only this much, my lord.
And fresh.
At least we need that statement.
Lordship.
As I have received the copy from, I'm submitting from the copy that I have received from the trial court.
Learned counsel for the petitioner and learned additional PP. Appears that the scanned copy of the TCR does not contain the
Entire CD, my lord.
entire CD, including the statement of the victim under 183 PRPC. BNSS. Learned code below is directed to furnish the same by the next date fixed. Is the matter again on
It will be prior to 20.
Hmm?
Prior to 20 of July. Like, any date prior to 20 of July.
prior to 20 already.
Subject to consideration.
17. Lordship.
May I please, Your Lordship, this matter may be taken up after some time. The reason lacks.
Record received, no.
Record also not received.
None appears. Record also not received. Send reminder.
27.
27. Hey, photo. 1 minute, 7 billion.
17.
Is enter list again on
17 Lordship. Deep blue.
It is your lordship. But the FIR is at page number 20, my lordships. On the last occasion, the CD was directed to be retained, my lords. But the FIR is at page number 20. With the
Yes,
page,
my lord, retained, my lord, but it is not with us, my lord.
Hmm?
I will, it is not in the record, my lord. Well, my lord, I can inquire in the second half, my lord. Or my lord, tomorrow, my lord.
basically, the allegations are that, my lord, we are the co-accused, my lords. Only on the statement before the police investigation officer by the main accused, my lords, I have been arraigned, my lords. And I have been
anyway, read
arrested.
the CD.
The second half.
But please,
TV timing.
May I please, Your Lordship? My case diary was called for. Allegation is by the theft and house trespass. This 10 is there, yeah. They are not the named accused.
Yes.
But there, though the no, not the name accused, but from the CD it reveals, my lord, they are, my lord, very much, they are with the, they are in a gang, operating in a gang, my lord. They, my lord, taken the, my lord, trunk which is full of, my lord, cash, my lord. Thereafter, this person, my lord, they succeeded in evading the police arrest, my lord. Some of were arrested, my lord. They have given their statements then, my lord. They have also got the share of money, my lord. And son, my lord, perhaps he is the owner of the car,
Vehicle
owner of the vehicle, my lord.
apply some materials, that is raw materials, the sand and grapes.
চুৰি কাণ্ডত কৰিবলৈ চুইফ্ট ডিজায়াৰ এখন আৰু মোৰ লগৰ ৰূপচান গাড়ীখন ব্যৱহাৰ কৰিছিলো। That is my other is
For-
one Nurul Islam.
Not a case of anticipatory bail. Maybe
Not a case
after.
of minor, because now the amount goes to more than 5 lakhs, my lord.
Recovered it.
Other things has to be recovered.
No, that money has already been recovered.
Imran and Rupsan, man, both are named, my lord.
With counsel for the petitioner. Application for free connection with so and so. For the allegation in the FIR. Person said broken
reading
into
one
the
line, my
house
lord.
of the
ইমৰানৰ
informant.
লগত জগদীশ তালুকদাৰৰ ঘৰত চুৰ কৰিবলৈ গৈছিলো।
Stolen a trunk containing valuable clothes and submitted that the present petitioner is named in the FIR and money has also been recovered. Learned additional PP with reference to the CD submits that although petitioner is not named in the FIR, there is sufficient material against him in the CD and the part of the cash amounting to rupees 5 lakhs has been recovered and other recoveries are yet
to be.
Hence, this is not a fit case for grant of pre-arrest bail. Accordingly, their stance rejected. This sent like that.
may I please, Your Lordship? My lord, here in this case, my lord, I am behind the bar since 81 days, my lord. The FIR is at page number 10, my lord. So far as the FIR, my lord, there is no any specific amount of dowry demand, my lord. So, my lord, kindly consider the length of detention and I may be allowed.
How much?
My lord, 81 days.
Can it be taken up in the second half if any CS has been filed? I also, my lord.
73 days.
81 days, my lord.
81 days.
81 days. 5-4.
All right, inquire.
Lordship.
Ali.
I mean, matter may taken up at 2 p.m. Small. Huh? I'm addicted. I mean,
Yes,
but in
what
this
is the
case,
difficulty?
entire allegation against the accused number 1 Miller, and petitioner is the father of the accused number 1 Miller, and some extramarital relation developed by the accused number 1 Miller, for which Miller, the informant went to the house of the petitioner Miller. Allegation is that Miller, petitioner and the other person assaulted the informant Miller. That is the allegation against the petitioner Miller. And rape part Miller, other parts is the against the main accused Miller, accused number 1 Miller.
Another case was there, I think, yesterday for 1.
I didn't went through, sir. I didn't go through for the first one, no, sir. Principal accused is accused number 1,
One.
sir. The father of the main accused.
And as per FIR Miller, there is nothing, only allegation
Is
against.
that when the victim approached father of present,
He sent him away.
he sent her away and bring her lordship.
And that is
No, he sent away the accused number 1.
Yes, he
somewhere.
facilitated the escape of the accused number 1 to somewhere unknown place.
To escape. He was not in custody. Bhaga diya, sort of thing. I passed an order in this. এই নামেদি চেক কৰিবচোন, কালি আছিল নেকি, কালিপুৰ একিউজডৰ নামেদি ইলিয়াছ আহমেদ, জাহিদুল হক, আজাৰ আলী something.
আছে নেকি আপোনাৰ মানে? চাওঁ, মোক কালি পাইছা।
Was the CD here? It was there yesterday also. We'll see after we come back.
Okay, okay.
Bless. কিন্তু কি করে এইটো ও বাইদেউ
Petitioner is my lord, he is a father of accused number 1. And against him allegation is my lord, she came to his house and he ousted her, my lord.
One co-accused was granted yesterday, I think.
Yes.
You heard the,
I am the father of the main accused.
that is number 2.
I am accused number 2.
Yes.
I am assistant teacher of a high school, my lord. And allegation is against me only that, my lord, when they came to me with a complaint, I ousted them, man.
Heard Mr. Chancellor. Order dated. Right. Here is bail. As per the FIR, the accused number one, who is the son of the petitioner, has been blackmailing the government lady several months. Also established forceful physical relationship with her. And 23/5/26, when she went to the house of the present petitioner, father of the petitioner had conspired and sent the accused number one to some other place. That subsequently they assaulted the physically her out of the house. Other than the above, there are allegations against the petitioner, present petitioner, the headmaster of a school, having regard to the above. The custodial interrogation of the petitioner is not considered to be necessary. Accordingly, provided that the petitioner will be released on dearest bail of rupees 3,000 with security of like amount to the satisfaction. It is further provided that the petitioner appear before the IO within a period of 10 days from today. That the petitioner shall not try to contact the victim or intimidate or influence the witness.
Obliged.
May it please your lordships. Senior had to leave due to some urgency. Lordships may have it immediately after the vacation.
All right. Wait for bail on counsel for the petition list again. Vacation immediately.
Meanwhile, if the case diary is traced out, my lord, the same may be retained.
40, 22.
Case diary may be retained.
Written. All right. Yes. Right.
May I please? Here in this case, my lord, I am behind the bar since 81 days, my lord.
Here charge sheet not laid down, my lord. But I'm praying, my lord, let it be on
Length of
July, my lord.
kindly length of consider the length.
Charge sheet.
Charge sheet not laid down, my lord. We have called for the city, but charge sheet till date it is not laid down. Yeah, my lord. Taken up on 2nd, my lord.
Is the date of arrest?
My lord, 5/4.
Arrest, my lord, on
5/4.
But she did not receive it again on 2nd of July.
Alia, please.
Hey, please, Your Lordship. The earlier occasion CD was called for.
CD not received, my lord. Dowry date, my lord. After the biggest, AB, my lord.
Mother-in-law and mother-in-law may be protected, my lord. Number 3 and 4, my lord. Name of the husband was already arrested, my lord. But fact is, my
How
lord,
many petitioners?
my lord, 8 petitioners, my lord.
What is the name of husband?
Husband is Sofiqul Islam, my lord.
He is arrested.
Hmm? Arrested already, my lord. Other is, my lord, brother-in-law and father-in-law, mother-in-law, and wife of the brother-in-law, father-in-law, my lord. So number 8 is the husband of the sister-in-law, my lord. He has been deciding the another village, my lord, court Timari. So number 7 and 8, my lord.
When was the FIR lodged? 22/4.
22/4, my lord.
Long back, sometimes. Right. I'd learned counsel for the petitioner. Additional PP. CD has called for has not received. Where it is submitted that the main accused of the case, that is the husband of the victim, has already been dead, and the present petitioners are the relatives of the main accused, including his father and mother. And more than 2 months have elapsed since FIR. IO is directed to fixed positively. It is provided that petitioners in the event of their arrest, connection with the aforesaid case shall be on bail of rupees 50,000 each. Like amount to the set. Just again on.
Only 3 and 4 may
Complex
be
will-
given, others may. Only 3 and 4 may be given, my lord.
Who are others?
They are the, my lord, parents, my lord. They are elderly persons, my lord, but others, my lord, they are.
So many, all the whole family has been, they will not be.
Obliged, my lord.
My lord.
May please your lordship. Lordship, earlier occasion CD was called for, lordship.
He did not receive, my lord.
Lordship, Lordship, only scratch marks has received.
Hmm?
Informant husband has received only scratch mark by a sickle, Lordship. In this case, Lordship, page number 20 is FIR. Lordship, informant husband has received only a sketch mark on his cheek and belly, Lordship. The sickle is not a sharp weapon, Lordship. It's light weapon, Lordship.
Sickle is not sharp.
Sickle is only used for harvesting paddy and cutting grass, Lordship. So is not done. Previous has not done by the sickle, Lordship. Petitioner's house has broken by the informant, Lordship. NBW
Where is the FIR?
page number 20, Lordship. Translated copy, page number 14. For a long time, informant husband had a bad intention on petitioner number 4, Lordship.
What is the stage of the case now? Charge sheet has been filed.
No, my charge sheet not filed. A CD call for my. Something has happened, my lord, as my learned friend has now said, my it is not
Hmm?
regarding the weapon. Something has happened, my lord, as my learned friend also said, my lord.
Petitioner
Yes, but it is serious hurt to my striking to my husband.
Lordship, petitioner number 3 is the minor, Lordship. I have annexed his date Aadhaar card, Lordship. Annexer 2, Lordship. Bisal Devnath. He is minor. NBW has issued against him, Lordship. And petitioner number 4 is pregnant lady, Lordship. Petitioner's house has broken by the informant and poultry farm has already destroyed by the informant, Lordship. They could not come home for NBW issue.
Accused 1 and 2 as per order of accused 3 and 4. Accused 1 and 2 assaulted as per order of accused 3 and 4. That is how they were.
But now NBW has been issued against you.
Yes, I have annexed that order copy, Lordship. Annexer 6, page number 22.
Nothing will be found. Injury. Learned counsel for the petition and learned petitioner people call for has not been received. Submitted that the accused number 3, a minor, while the petitioner number, all 4 petitioners are here.
Yes, Lordship.
They should also have come up for a through a criminal petition, my lord, because of the
Pregnant and in an advanced stage of pregnancy.
Annexure 4 is the doctor prescription, Lordship. Petitioner number 4. Page number 30.
PO is directed to PD. Next date fixed. The of the allegations, the fact that the FIR was long back 12/25. I did that. আগৰ কেছটোৰ দৰে একেই।
Obliged.
May it please your lordship. My lord, pre-arrest bail application, my lord, and my lord, land dispute is there, my lord, and cross cases are also there, my lord. We also filed, my lord, they also filed, my lord, and all family members and relatives are implicated in this case, my lord. 2 persons have already been arrested, my lord. And one petitioner here, my lord, petitioner 18 is 80 years old, my lord. All family members and relatives are implicated, my lord. My lord, may I pray for interim, my lord, because we have to produce our land documents also, my lord. FIR page, my lord, 13. FIR itself, my lord. Here, that my lord, there is a property.
some cases are fixed in the vacation, my lord.
In connection with this.
Yes.
2nd July, my lord. That is BA, my lord. This is AB, my lord.
All right,
My
let
lord,
it be fixed then. We did not receive list on 2nd of July.
Along with my lord, BA number 1646. Published.
Wait, please, your lordship. In this case, previously we were on interim protection and CD was called.
You received, my lord.
FIR is at page number 9. We appeared before the IO, your lordship. May I read the FIR, your lordship?
Yes, where is the FIR?
The FIR is at page number 9, your lordship.
Time was.
May I read the FIR? Sir, it is most humbly submitted that I am a permanent resident of the above mentioned address and is an Agarud businessman by profession. On 29th December 2024, the accused person number 1, that is Badrul Islam, purchased Agarud from me worth rupees 12 lakh. Accused person number 2, that is Ziaur Rahman, was actively involved in the trade as an agent of accused number 1. As per the terms of the agreement, they were supposed to pay the entire amount within 15 days. However, even after 2 years, they have not paid the money. When I went to the house of the accused demanding money from them, they have threatened me by saying that they will pour petrol on me and burn me and also threaten me with a gun. These threats have put me and my family member in great mental pain. The accused persons from many years in a similar manner have been purchasing agarwood from many small traders in Hojai districts and looting their money by breach of trust.
Yes, think from other victims and all.
Yes, my lord. My lord, several victims were, my lord, now, my lord, examined, my lord. According to my lord CG, my lord, from one accused, one victim is 12 lakhs is due, another, my lord, 7.15 lakhs, another person 26 lakhs, another person 18 lakhs, my lord. My lord, my lord, as per the, my lord, only one FIR is there, but he does this, my lord, to all the other persons, my lord. He tells that he will give the money, he takes it and never pay amount, my lord. So he is in he is habitual, my lord.
Your Lordship, this
Not only one case, my
this
lord.
particular business, Your Lordship,
Well,
agarwood.
and secondly, my lord, though he has appeared, my lord, but in the subsequent stage, my lord, he was called for, my lord, he has switched off the mobile. And in his bailer also called for, my lord, bailer also switched off the mobile, my lord. It's my lord, it is, and thirdly, my lord, the video analysis was done, my lord, and his presence was there in the place of occurrence in the
Lordship, our case is simple to that effect that these are not the simple people. It's a businessman which goes in crores, Your Lordship. The business transaction happens in crores. These are one of the people from whom we have purchased, and due to the Middle East crisis, he's unable to settle the money, Your Lordship. This is not just 2 or 3 transactions. Multiple number of transactions keep happening, and in a regular manner, the money keeps going away to the person who has sold the goods, Your Lordship. This case clearly falls within the ambit of Sale of Goods Act, for which there is a particular act and there is a particular remedy, Your Lordship. Here, in turn, they are trying to use the police machinery for recovery of money with regards to a business transaction purely, and no criminality or criminal liability has been invoked, Your Lordship. Furthermore, Your Lordship, with regards to the submission that his phone is off or his bailer's phone is off, to that I would like to take an instruction, if I may be allowed to take an instruction, because he has appeared before the IO, recorded his statement, and he's ready to and willing to appear. Even if the court directs tomorrow, he's ready to appear. Just to the effect that whether the police is calling him, what is the phone number, that part I would like to take an instruction, Your Lordship. Other than that, this is purely a matter of Sales of Goods Act, for which there is a specific statute and specific remedies before the court of law, which he may avail, while the people who are being allegedly shown as victim, they may avail. But in my case, Your Lordship, there is no criminal liability attached to the accused person, Your Lordship. And money has been paid out on a rolling basis, Your Lordship. This is business transaction simply, Your Lordship.
But that's simple, my lord. Those, my lord, several lakhs of rupees from everyone, my lord.
Your Lordship.
If your business is stop, my lord, why you are taking again and again if you could not, my lord, export it to Middle East, my lord? He keeps on, my lord, taking the agoro, my lord, without making payment. There are sales of goods, again, other things are there. Now 3184, there is cheating is also my.
It is their statement.
Yes, my lord.
What have they said about this?
Regarding, my lord.
Regarding
Yes.
this taking of the money and
Yes, my this is my
taking of the agarwood.
Yes, your মানে মোৰ পৰা 7,15,000 টকাৰ আগৰো কিনে জিয়াউৰ ৰহমানৰ কথাত মই বাকী দিলো পইচা দিম বুলি from 29/12/2024 মানে it is মই কাৰ্ড দিছিলো কিন্তু আজিলৈকে দিয়া নাই বিচাৰিলে পেট্ৰল ঢালি জ্বলাই দিম বুলি ভাবুকি দিয়ে statements and it is the 183 statements not one.
What is the statement of the accused?
Accused, my lord.
What is their explanation?
Yes. The statements were taken, but the statements are not a part of the minor.
Then let's have it updated.
Lordship.
And you also take instructions in
Indeed, Your Lord.
Learned counsel for the petition. A result of the CDHC that the statements of the petitioners recorded pursuant to hearing protection available. Send back the CD for resubmission along with the statements of the accused persons. Again on date of listing.
Out of them, last note, my lord. May I pray that he may appear again? That will be, my lord. Perhaps, my lord. The investigation, my lord.
That
Last note of the
in
IOT.
case
He has
the
not
statements have not been recorded, they are recorded. That is, no, we'll not say we'll not recorded. We'll just say that
Yes, sir.
petitioners are further directed to
Further
appear
directed.
before
That-
the IO within a period of
Yes,
10
that
days
will be
for
my-
today. Since it is submitted that the IO has been trying to contact the petitioner, but have found his mobile phone switched off.
Deeply obliged, Your Lordship.
May I please, Your Lord? So in this case, injury report was called for. The petitioner is was granted interim by order dated 13/3/2026.
Received.
Injury is received, my lord. A mild laceration and swelling, simple injury, my lord.
Right. Order dated 13/3/26. Four. CDS call for has been received along with injury report which indicates simple injuries only. Considering the above and the nature of the allegations. Therefore, pre-arrest bail is allowed. Of interim pre-arrest bail dated 13/3/26 is hereby made absolute on the same terms and conditions.
Much of.
This one was
Wait, please, Your Lordship. Wait, please, Your Lordship.
What's it? Matter has been settled outside the court at rupees, amount of rupees 7 lakhs. Lordship.
Third, learned counsel for the and learned counsel for respondent number. Here is the Communication dated 04/06/20 submitted from the insurance company to the Registrar General, Guwahati High Court. Indicating that the matter has been settled an amount of rupees 7 lakhs.
Additional amount.
Additional amount of rupees 7 lakhs. It is paid.
No lordship. They have to pay.
So
Audit amount already paid, Lordship. We have to pay additional amount of rupees 7 lakhs, and that will be deposited before the registry, Lordship.
Hmm?
We'll deposit the rupees 7 lakhs within a period of, Lordship, 4 weeks before the registry of High Court.
accordingly, the insurance company is directed to deposit the amount of rupees 7 lakhs for the registry of this court within a period of 2 weeks from today.
Claimants may be allowed to withdraw the same.
Upon such deposition, claimants are permitted to withdraw the same following usual procedure.
Yes, lordship.
We close this.
Lordship.
Of one settlement.
Matter also settled.
Connected miscases also stand disposed of. Yes,
This
this
matter also lordship has been
They're
settled.
going to pay additional amount of 4,30,000 in this case. Lordship.
communication is there. No. Get to 11/6/26 and we amount to 4,30,000.
Obliged, lordship.
Obliged, Lordship.
My lord, we have taken the step, my lord, in that yellow flag, my lord. The office note dated 22/6, ma'am. So,
Lordship, we have served upon respondent number.
Served. Counsel for the petitioner. Learned additional PP on instructions received submits that notice. Respondent number 2 has been served. Sir. See. Oh,
Service report may be kept.
concerned police station. Kept on record. And appears for the respondent number 2. Accordingly, so and so is appointed as.
early date may be fixed after vacation, my lord.
Appointing someone. Amicus.
Ms. L. Devi, Lordship.
Of the petition be served upon.
Obliged, Lordship.
Can it be on 15, 16 July? This week, my lord, 13 to 17 in
13 to 17 July.
time, my lord. Date, my lord. Time may be continue, my lord. Interim is there.
Your Lordship.
We have filed IA Lordship 445/2026 Lordship for suspension of sentence Lordship. Last occasion Lordship into some Lordship Tasman Lordship regarding Lordship applicability of section 436A present BNSS 479 Lordship.
Much time spent
8 years, 2 months almost
out of 10 years.
out of 10 years. Arrested on 8/5/2018. A flag mark it Lordship. Case 56, paragraph 56. 657, 63, 60. Okay. Satyendra Kumar.
Yes, Mr. Dev Chaudhary.
Viral with the proposition. Just spent very small portion of the sentence. It
Remains.
remains. Instead of going into the IA, here I pray before your lordship that the appeal may be decided. Let it be at the early date, because if the IA is gone into, then we do not know when the appeal will come. Let the appeal be decided, lordship. As it is, while while staying the sentence, lordship has to give the reasons. And if your lordship has to give the reasons, lordship has to go through the whole judgment. Why not go through it once while deciding the judge? Immediately on reopening, let it be on 13th or 14th, lordship will decide the appeal itself.
Yes. What is your response?
A very new case, Lordship. I don't know Lordship, if your Lordship fixed for the case for hearing, it will be get listed and be heard, Lordship, because record has not come on last 2 occasions, Lordship. The record available, Lordship. They have already undergone substantial portion of the sentence.
Record will come, don't worry about that.
If it is
This is a very, if they have approached the court very lately, that is for legal service authority, Lordship. Appeal is very new, Lordship. If it is
Appeal may be new, but because of the fact that he has suffered incarceration for almost the entirety of the, why can we not take it up for final disposal? We had heard Mr. Learned counsel for the applicant. Architects, senior counsel representing the, what is this? NCB. That since the petitioner has spent a very substantial portion of the sentence, completed a very substantial portion of the sentence from other, their appeal may be heard and disposed of at the earliest. However, it is noticed that the PCR have not yet been received, although called for 15/6. Very recently called. It may be already on the way. Because original is going to come.
from Kamrup, coming from Kamrup Metro.
They have to prepare the file wise. Otherwise, these things lie there in a very disabled form. Once the High Court calls for it, then only all the pages and everything are prepared serially. A file, B file, C file. This is Metro.
Yes, Lordship.
Accordingly, registry to issue reminder. District and Session Judge Kamrup is directed to ensure PCR by the next date fixed. The matter for hearing on. Yes, give. All.
Can it be on 60?
Hearing day.
I don't know, Lordship.
Thursday.
Except 14, Lordship. For 15 or 16.
16. I do. Can take it back.
Wait, please. Appeal against conviction, Lordship. I was convicted for 10 years along with the IA for bail. Lordship. Now, here in this case, there is no substantial or acceptable evidence because the alleged victim has died during the trial. Her statement could not be recorded. Now, the only 5 witnesses were examined, the short witnesses. PW 1, 3, and 4 are the PW 1 is the informant, 3 and 4 are the neighbors. PW 2 is the police personnel who submitted the charge sheet, and the PW 5 is the as a writer. The 1, 3, and 4 who were examined are the reported witness, and there is no corroboration because the victim, alleged victim, she died. And neither the 164 statement recorded during the trial could be exhibited because judicial magistrate who examined the victim was not examined. Neither medical officer was examined. So we are left with only 1, 3, and 4 who are all reported witness, and there is no corroboration because the victim could not be examined. And the narration, there is no narration of the incident. All the witnesses.
What is the basis on which the conviction has been returned?
Because they have said that the rape was committed. The reported witness has said the rape has committed, and the rape was what was used. That much only. There is no narration of the incident. So court could not adjudicate whether that incident was exactly was a objection quoted 12/6/26 of quoted. But this is objection filed for revoke and independent.
And the IA, my lord, they allow us some time to file an objection. 10 years punishment is there mandatorily, my lord.
Also, there is no material to raise objection.
Well, it is their protocol.
Lordship.
Because my, it is 10 years, my lord, we have to file.
They have some sort of circular. When it is 10 years, they have to file objection mandatorily.
At 12 to 26, Lordship will find order. They were given opportunity to submit an objection.
TCR has come now.
12 to 26.
Now only TCR has come.
TCR was not available
Not
then.
available.
Mr. Applicant. An additional PP press for some time to file objection. As TCR was not received earlier. Where is allowed the matter again on
21.
this in the IA, okay?
Oh dear. Only fix on 24.
Not sure.
Lordship, in a delay petition notice was issued. Today is fixed for status report from the public prosecutor
Status of what?
regarding service upon the informant.
This is awaited, my lord. This is awaited.
Additional public prosecutor submits that service on.
Has come, my lord.
It has come,
Yes.
complete
Yes.
as per instructions received. However, none appears accordingly. What is this matter appeal against?
Appeal against conviction, Lordship, POCSO.
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 Karen Brown.
Obliged.
Hearing items are fixed on this.
Lordship, Lordship order dated 30 April 2020 directed to deposit some amount.
So you have deposited something.
Lordship, we couldn't deposit the 50,000 as directed by the court during the last month due to some issues, Lordship, but we have deposited an amount of rupees 1 lakh, Lordship.
How much remains now?
5 lakhs, Lordship.
And when are you going to deposit?
Lordship, the rest will be deposited within the next 4 months, Lordship. We have been granted a time period of 6 months, Lordship.
It had learned counsel for the petitioner and learned
Department 2.
stated that an amount of rupees 1 lakh has been deposited by check dated 25/06/2026. Before the registry.
But
You have withdrawn.
No, Lordship. I know I have been informed that it has been. I may be allowed to withdraw, Lordship.
Sole respondent, is it?
Respondent, Lordship.
Respondent is allowed to withdraw the same.
Respondent number 2. Respondent number 1 is the state formal party.
2 is allowed to withdraw the same. Submitted that the remaining amount shall be paid within a period of the remaining 4 months. You'll be making in one go or in installments?
Lordship in installments.
So another 1 lakh next month?
Sir.
What? Out of which rupees 1 lakh will be paid within the next 30 days.
Lordship.
Is the matter again on next month, same date.
Yes, Your Worship.
I may be allowed to withdraw that amount
Yes, we have said.
of like.
May I please, Your Lordship? I am appearing on behalf of the respondent number 2, my lord, Chief Security Committee.
It's appearing. Why? Last date also nobody appeared.
Yes. Actually, this case is not sustainable, my lord. As what the ground they have taken under section 313 of the CRPC, accused was not examined. But it was, as per the order passed by the railway magistrate, in CR case number already under section 313 of CRPC, accused was examined. It is on record. And the decision session court also in criminal appeal upheld the judgment of the railway magistrate. So now but he never has raised this point that under section 313 of CRPC, accused was not examined. If actually it was not examined, he could have taken ground under section 391 of CRPC that this ground was not taken, he should be further examined and matter may be remanded back to the railway magistrate. But this ground was not taken before the appellate court. Now in the High Court, he is taking this ground. Yeah, in Annexure 1, page 10 of the memo appeal, ACS division petition, in CR case judgment dated 3/11/2014, passed in CR case number 82 of 2007, in para 3, 11 page 11, may I read, my lord? During trial to prove this case, the prosecution examined 5 numbers of witnesses, namely Sri Manoj Kumar Das, PW2, Muhammad Mumtaz Ali, PW3, Muhammad Shahim Mirza, and PW4 Sri Bimal Chandra Das, PW5 Sri Amrit Chandra Rabha, and Sri Arvind Kumar as CWT1 statement under section 313 of CRP is recorded in a separate form, wherein he pleaded himself to be innocent and the defense reduced to no evidence on the. It is already mentioned, my lord. And accordingly, and he was convicted, sentenced only for small imprisonment for 1 month with fine of rupees 2,000. And then he challenged before the appellate court, and appellate court upheld this judgment of the railway magistrate. Now he is approached to for this appeal before the honorable court, challenging on the ground the accused was not examined under section 313 of the CRPC. On the last 2 occasions, he is not appearing before the court, my lord. That's one more.
This ground taken violation of search and seizure was not carried out as per section 10 and 11 of CRPC.
Yes, my lord, he is taking all the provisions in against the,
Section 10 is subordination of assistant session judge. 11 is courts of judicial magistrates.
yes, my lord. If there any mistake before by the relevant state, my lord, under section 391, he could approach to, by preferring appeal, he could demand the re-examination of the accused.
None appears for the petitioner. So and so appears for
As for number 2, Chief Security Commissioner RPF.
respondent number
2.
2.
1 is the state of Assam.
State of Assam is represented by learned additional PP. So by way of the instant criminal petition, challenge has been put to the appellate judgment and order. You see the cause title. Okay. On perusal, page 28. Okay. Part 2, 3, and 4. There are being aggrieved, the petitioner heard an appeal was confirmed by the learned session judge, which was dismissed by the learned session judge, thereby confirming the judgment and sentence of the learned trial court. Hence this petition. The only grounds of challenge as reflected in the memo of appeal are that before making any search and seizure, there was no compliance with the provisions of section 10 and section 11 of the CRPC, which is mandatory. Secondly, that the petitioner was not given an opportunity to defend his case, nor was he examined under section 313 CRPC by the learned trial court. As far as the first ground is concerned, section 10 and 11 of the CRPC have nothing to do with search and seizure procedure, which is covered by section 100 CRPC. In this regard, the learned session judge has dealt with the aspect as follows. Page 31. Para 9 down below. Third line from bottom. Till the end of that paragraph. Okay, that's page 32. Further, as regards the second ground of non-examination of the accused under section 313 CRPC and not being given opportunity to produce defense evidence. Perusal of the trial court records clearly shows that the matter was very much examined under section, record of which is found like to adduce defense evidence, the petitioner in the negative. Therefore, the second ground also has no basis. Having regard to what has been discussed above, I do not find any merit in the instant petition, and accordingly the same must send back the records.